Good morning, colleagues, senators, central staff, Senate staff, and our listening as well as viewing audience. The 36th Legislature of the Virgin Islands Committee on Rules and Judiciary hearing for Thursday, January 8th, 2026 is hereby called to order. Happy New Year 2026 to everyone. Time passes quickly. Thank you to my staff, colleagues, and our central staff for your work and service to the people of the Virgin Islands in 2025. Last year, this Committee on Rules and Judiciary successfully held 11 meetings, vetted 81 bills, with 79 of those bills were favorably moved to the full body for further consideration and action. Additionally, the committee considered 21 nominations from the Office of the Governor for our boards, commissions, and judiciary, and today's nomination of Attorney Pedro Williams will increase that number to 22. This is the first committee to hold hearings for the year of 2026. And as we continue our work at the beginning of this year, I look forward to conversations and the importance of programs like SNAP, Medicare, and the like being part of our discussion. I also look forward to meetings with my colleagues and the people of this territory to establish workable solutions that will strategically and positively position our people and this territory for the future in the ever-changing landscape of our world and this region. Today, January 8th, is National War on Poverty Day. War on Poverty Day is observed annually on January 8th. I want to say that again. War on Poverty. To reflect on the impact of the legislation introduced by then President Lyndon B. Johnson in 1964. This initiative aimed to address the high poverty rate in the United States, which was around 19% at that time. And many of us know that we are here in the Virgin Islands still experiencing that level of poverty, especially when we are seeing from the national level that even our child care services funding to help those most in need are being questioned and are being held back. The fight must continue for us to bring down those walls of poverty. I want to also mention that last year, with the federal government shutdown, we saw how important these programs like SNAP, TANF, played in our Virgin Islands. This legislature, we could not jeopardize those persons who are more in need, much in need, from not having that type of service and those funds and resources. So we had to make a major decision to take money from one pot that was there to help to provide other services to assure that those individuals who were on SNAP, which was called before food stamps, so the lay people would know, would be able to collect that resource and help feed their children. Let us be committed to providing economic opportunities, securing resources for those in need, making necessary investments, and forming strategic relations to improve cost of living factors in our beautiful Virgin Islands. Tomorrow, January 9th, is National Law Enforcement Appreciation Day. We say thank you to all the men and women in law enforcement throughout the Virgin Islands, as well as in the United States, including our legislative security, my Sergeant of Arms who is serving here today, and who work daily to uphold the law and maintain peace and order as they serve to protect the people and property of the Virgin Islands. Thank you. We appreciate your service. And finally, we say Happy Independence Day to the people of Haiti and Haitians within our community. On January 1st, 2026, Haiti observed its 222 years of independence from France. That's a monumental achievement for our brothers and sisters from that island nation. While Haiti continues to face widespread gang violence, mass displacement, and a stalled political process, we are hopeful that one day order is going to be restored and a new path forward for that country. Every country has its share of challenges, and this is a fact. And some have it more than others. We look forward with great hope and prayers that the people of Haiti in our Caribbean region and our Virgin Islands will have that one day that some of these challenges are no longer and are a part of our history to build upon. Here in the Virgin Islands, I will let us do our part to live peacefully with each other and with our neighbors in the Caribbean region. Once again, on behalf of my family and staff, I wish everyone a healthy, joyful, and prosperous New Year. May God bless us all. Madam Clerk, kindly proceed to roll call.
Senator Angel L. Bocas Jr.
Present.
Senator Bocas, present. Senator Kenneth L. Gittens. Senator Gittens, absent. Senator Alma Francis Heiliger. Senator Francis Heiliger, absent. Senator Carla J. Joseph.
Present.
Senator Joseph, present. Senator Clifford A. Joseph, Sr.
Present.
Senator Joseph, Sr., present. Senator Avery L. Lewis.
Happy New Year. Present.
Senator Lewis, present. Senator Milton E. Potter.
Here.
Senator Potter, present. Madam Chair, you have 5 present, 2 absent.
Thank you so much, Madam Clerk. And thank you, members, for being here. Madam Clerk, we have a quorum. Madam Clerk, do we have any correspondence?
Yes, Madam Chair, we do.
Kindly proceed with reading those correspondence into the record.
Letter dated January 7, 2026, to the Honorable Carla Joseph, Chairwoman, Committee on Rules and Judiciary, 36th Legislature of the Virgin Islands, Capitol Building, Charlotte Amalie, USVI 00802. Dear Chairwoman Joseph, I am writing to formally advise that I will be unable to attend the Committee on Rules and Judiciary hearing scheduled for Thursday, January 8, 2026, due to a medically necessary appointment that cannot be rescheduled. I apologize for my absence and any inconvenience it may cause. I kindly ask that the committee forward all pertinent information and updates from the agenda to my office for review and follow-up. Thank you for your understanding. Sincerely, Kenneth L. Gittens, Senator. Letter dated January 8, 2026, to the Honorable Carla J. Joseph, 36th Legislature, Chairwoman on Committee on Rules and Judiciary. Greetings, Senator Joseph. Please note for the records, I will be tardy to the Committee on Rules and Judiciary scheduled for 10 a.m. on Thursday, January 8, 2026, in the Earl B. Otley Legislative Hall due to a previously scheduled appointment. I will arrive as soon as possible. Thank you for your understanding. Regards, Senator Alma Francis Heidegger, 36th Legislature, Member of Committee on Rules and Judiciary. Madam Chair, this concludes the reading of the correspondence.
Thank you, Madam Clerk. Madam Clerk, kindly mark Senator Gittins as excused absent, as well as Senator Alma Francis Heiliger as excused absent, and give us the tally.
Madam Chair, you have 5 present, 2 excused.
Thank you so kindly, Madam Clerk. Madam Clerk, kindly proceed with reading Block 1 of today's agenda into the record.
Please be advised that the 36th Legislature of the Virgin Islands Committee on Rules and Judiciary has scheduled a hearing for Thursday, January 8, 2026 at 10 a.m. in the Earl B. Otley Legislative Hall on St. Thomas. The purpose of the hearing is to receive testimonies from the governor's nominees and to consider the following legislative measures. Block 1, Mr. Pedro Williams, Esquire, governor's nominee for judge of the Superior Court, Division of St. Thomas, St. John. Madam Chair, this concludes the reading of Block 1.
Thank you, Madam Clerk. And we have with us today in Block 1 the governor's nominee for judge of the Superior Court, Division of St. Thomas, St. John, Attorney Pedro Williams. Attorney Williams, I see that you have brought a whole household of supporters here. Are you guys trying to intimidate us? Are you physically showing us the level of support, the variety of support that you have here with you and who back you? Okay, and that is fantastic. I really appreciate that. So part of the process that we undertake in the Committee on Rules and Judiciary for all nominees, no matter what level that they will be serving, is that we swear you in. And so, Attorney Williams, and you're very familiar with this because I serve as the ex-official member of the PAC, and you serve still as the chairman. You swear in our testifiers. Kindly stand and raise your right hand. Do you solemnly affirm, under penalty of perjury, that the testimony you will give to this committee will be the truth, the whole truth, and nothing but the truth to the best of your knowledge and belief?
I will.
Thank you so much. Please be seated. I want to, at this time, before he knocks my head off, right, to recognize my good colleague and former co-worker and the chairman of a wonderful committee that I have the pleasure of serving on, the Committee on Housing, Infrastructure, and Telecommunications, Senator Marvin A. Blyden, a non-committee member, but he has made sure he's taken time out of his busy schedule to be here for today's hearing. Thank you so much, Senator Blyden, for being here. And Madam Clerk, kindly note that as part of the record today. Mr. Williams, kindly proceed with reading your submitted testimony into the record.
Good morning. Honorable Carla J. Joseph, Chairwoman, and other distinguished members
come a little closer to the mic, Attorney Williams. Speak clearly into it because we want everybody to hear. Thank you.
Good morning. Is that better? Honorable Carla J. Joseph, Chairwoman, and other distinguished members of the Committee of Rules and Judiciary of the 36th Legislature of the Virgin Islands. My name is Pedro K. Williams. I am pleased to appear before you today as a nominee for confirmation to serve as a judge of the Virgin Islands Superior Court, Division of St. Thomas and St. John. First, I give honor and glory to my Lord and Savior Jesus Christ, who is the light of my life and my Redeemer, who has given me life. Second, I want to thank the Honorable Albert Bryan Jr., Governor of the U.S. Virgin Islands, for nominating me to this position. Third, I want to extend my gratitude and love to my wife of over 40 years, Naomi Williams, my children, Kelsha and Janae, their spouses, Carla and Odari, and our 6 grandchildren, soon to be 7, for allowing me to give up my time to serve our community. Fourth, I want to thank my pastors, Reverend Dr. Trevor Campbell and Georgie Phillips, and church family at St. Thomas Assembly of God and others gathered here today for their continued prayers and support for me on this new journey. Those of you who don't know me, I want to introduce myself. I was born on the island of Antigua, and my family relocated to St. Thomas when I was 6 years old. The Virgin Islands has been my home ever since. I'm a 1978 graduate of Charlotte Amalia High School. In 1982, I graduated with a degree in economics from Tufts University in Medford, Massachusetts. I then attended the University of Texas School of Law in Austin, Texas, from which I graduated with a JD degree in 1985. Upon graduation from law school, I began employment as a legislative assistant in Washington, D.C., to the Honorable Ron DeLugo, VI delegate to Congress. I later became chief counsel to Delegate DeLugo. 2 years later, I returned home to St. Thomas to assume the role of district manager of his congressional office in St. Thomas. In those roles, I drafted legislation, conducted research, and provided legal advice. I also served as the liaison between the local government and federal agencies. I also drafted speeches, memorandum of law, and position papers. I further represented the congressmen at official and social functions, both on the federal and local levels. 2 years later, in 1989, I left the congressional office to assume the duties of legal counsel to the Virgin Islands Coastal Zone Management Commission at the Virgin Islands Department of Planning and Natural Resources, where I provided legal advice to all 3 Coastal Zone Committee management committees. As CZM counsel, I represented the various Coastal Zone Management Committees before the Virgin Islands Board of Land Use Appeals and the courts. My responsibilities included preparing trial briefs and other pleadings. I also provided legal advice and counsel to the commissioners of Planning and Natural Resources, Attorney Alan D. Smith, and later Roy E. Adams, and other senior staff. I was responsible for the administrative prosecution of persons or other legal entities who were cited for violations of the Coastal Zone Management Act. I also drafted rules and regulations for the department and assisted with the initial drafts of the Virgin Islands Development Law, more commonly known as the Land and Water Use Plan. In 1991, I left DPNR and entered into private practice of law as an associate in the law offices of Vincent F. Fraser. A year and a half later, in 1993, I became a partner in the law offices of Fraser and Williams. Attorney Fraser and I remained law partners until he assumed the office of Attorney General of the Virgin Islands in the John P. DeYoung administration in 2007. From 2007 to 2022, I've remained in private practice as the law offices of Pedro K. Williams. In 2023, the office was renamed as the law offices of Williams & Williams when my son, Kelsha, became a partner in the firm. While in private practice, I've had the privilege of engaging in the general practice of law, where I've represented numerous individuals, organizations, and businesses in a variety of legal matters. Some of our clients have included the Board of Trustees of the GRS, the Virgin Islands Board of Education, the Virgin Islands Department of Labor, where I have served as an administrative law judge for unemployment claims, and the Virgin Islands Housing Authority. Over the years, we have represented numerous labor unions, including the American Federation of Teachers, the Firefighters Union, the United Industrial Workers or Seafarers Union, and the St. Thomas and St. John and St. Croix Educational Administrators Association. We've also represented the St. Thomas East End Medical Center Corporation and the St. Thomas Federal Credit Union. Our clients include other small businesses, churches, community organizations, and of course, individuals. Over the years, I've served on a variety of both public and private boards to include the Virgin Islands Housing Finance Authority, Legal Services of the Virgin Islands, the Women's Resources Center, now known as the Family Resource Center, the Virgin Islands Bar Association, the Virgin Islands Law Revision Commission, and Prophecy Academy, Inc. I've served on the board of deacons or directors of my church, St. Thomas Assembly of God, for the past 36 years, and I've also served as church administrator, youth director, and Sunday school teacher. I've held leadership positions in the Parent Teachers Associations for every school that our children have attended. I've previously served as counsel to the territorial and district committees of the Democratic Party of the Virgin Islands. From January 2024 to present, I've served as chairman of the Virgin Islands Public Services Commission, a quasi-judicial body. As an attorney licensed to practice in the Virgin Islands, I've appeared before the VI Supreme Court, District Court, Appellate Division of the District Court, the Superior Court, and the Third Circuit Court. I've also practiced before administrative agencies, such as the Public Employees Relations Board, known as PERB, the VI Board of Land Use Appeals, and the Virgin Islands Department of Labor, Wrongful Discharge, Unemployment, and Workmen's Compensation Divisions. I've also arbitrated many cases on behalf of unions such as St. Thomas, St. John, and St. Croix Educational Administrators Association, St. Thomas, St. John American Federation of Teachers, United Industrial Workers, and the Firefighters Union. My work experience has involved both criminal and civil cases. I've tried criminal cases ranging from simple assault, possession of unlicensed firearms, unlawful sexual contact, to murder. On the civil side, I've tried forcible entry and detainer, FED or eviction, guardianship, custody, divorce, and represented minors before the family court. My litigation experience has involved temporary and permanent restraining orders, injunctions, foreclosures, personal injury, medical malpractice, wrongful discharge, discrimination, breach of contract, partitions, and probate. I've represented clients in real estate transactions, both sellers and buyers. With the exception of admiralty, taxes, and bankruptcy, I've practiced in about every area of the law. As such, if confirmed for this nomination, I will bring my almost 40 years of legal experience to the bench. I must admit, being a judge is an awesome responsibility. I would have the responsibility of the lives of individuals in my hand, especially in the criminal area, where I may be required to sentence persons for the rest of their lives in prison. In civil cases, I would have to decide who wins and who loses. As such, I would need much wisdom to make decisions. I would hasten to add that we have been blessed in the Virgin Islands with a judiciary that is second to none. The judges in the Superior Court have set the bar high for us to follow. As a judge, I pledge to be fair, unbiased, respectful, and empathetic. To accomplish these goals, I must know the law and be able to apply the law to the facts and understand how my judicial decisions will affect the persons appearing before me. I'll be required to render judgments that are fair, impartial, and just. It will require that I treat each party in council with respect and empathy. I also truly understand the legislature's, community, and frankly, my colleagues' concerns about the court's ability to move cases. I understand that justice delayed is justice denied. The court must find and implement more meaningful ways to move its docket. As such, I pledge to work hard and apply myself to move cases along. This will include but not be limited to ruling on cases from the bench so that in appropriate cases, litigants will know where they stand when they leave the courtroom. Also, I commit to issue timely written decisions and opinions. Of course, none of that can be done in a vacuum without the appropriate assistance from support staff, clerk of the court, and others to assist in keeping track of cases and moving cases. Much has been said about the court granting numerous continuances in cases. I will hasten to add that there are legitimate reasons for continuances. However, a judge must know the counsels appearing before the court and whether they are being provided with legitimate reasons for continuance or counsel who has not done the work and prepared for trial. I will be able to tell the difference and will act accordingly. I don't take any of these responsibilities lightly, but will base my decisions on the law, my legal experience, as well as my life experiences as a person who has grown up in this community, knows this community, has been involved in this community, and only want what is best for this community. Should I be confirmed to the position of judge of the Superior Court, I'll do my utmost to follow in the footsteps of our great jurists and leave a legacy for others to follow. If I'm confirmed to this position, I pledge that I will use the legal skills I've developed over the past 40 years to benefit the people of the Virgin Islands. I will use my ability to analyze complex and voluminous information and other issues to make prudent, fair, and reasonable decisions. I'm a problem solver and decision maker. I'm well organized and can multitask. I'm a quick study and can review and comprehend voluminous documents in order to make decisions. I have no problem in learning new things and being able to conduct research to get answers to questions. Senators, I welcome this new challenge of serving as a judge in the Superior Court of the Virgin Islands, St. Thomas St. John Division. I humbly ask for your support and trust in my ability and commitment to work on behalf of the people of the Virgin Islands. I ask that you favorably consider my nomination. That completes my prepared remarks. I'm available to respond to the many questions that I know you must have.
Thank you so much, Attorney Williams, for that very thorough presentation. I mean, you are one of the first persons, and I've been on this committee for the time I was elected from 2021, and your testimony and your experience in as an attorney is very widespread compared to others, and I really appreciate all the work that you have done over the 40 years span working here in the Virgin Islands. This time I would like to recognize the chairman of the Committee on Budget, Appropriations and Finance, who has joined us from the conference room in St. Croix, Senator Novell E. Francis Jr., and also, I'd like to recognize the presence of committee member Alma Francis Heiliger. Welcome, senators. Madam Clerk, kindly give us the total tally of members present.
Madam Chair, you have 6 present, 1 excuse.
Thank you so much. And so we have a good quorum here to have a very great conversation with you, Attorney Williams. The order of questioning will be as follows. We begin with Mr. Secretary Avery Lewis, followed by Senator at Large Angel Boquez Jr. Then we have Clifford A. Joseph, followed by Mr. Senate President, Mr. Senator Milton E. Potter. Next, we have non-committee member Marvin A. Blyden, followed by non-committee member Novell E. Francis Jr. Then we have committee member Alma Francis Heiliger, and then I will round up the whole line of questioning. With that being said, Mr. Secretary, kindly proceed with your 4 minutes of questioning.
Good morning
Good morning.
and Happy New Year to one and all. Good morning to my colleagues. Good morning to Central staff, my staff. Good morning to the people of the Virgin Islands. Attorney Williams,
Good morning, Senator.
how are you keeping today?
Louis. Good.
Well, it had to rough up a man walk with the whole church, my son. So I gonna behave myself because all of them equate to something. But that's good to see that a man of faith is moving forward and accept the nomination. But before I get to you, I think, Mr. Conero, today's your birthday? Happy birthday, Rafi. Happy birthday. May God bless you with many, many more. And enjoy your day. Attorney Williams, you have practiced law in the Virgin Islands for nearly 4 decades and have represented a wide range of clients, to include the AFT. How will you ensure that your prior professional relationships and advocacy roles do not affect your impartiality as a judge?
Senator Lewis, obviously as a judge, I have to be impartial. We do have rules of conduct for judges that determines how we should operate. Obviously, if I represented somebody as a lawyer, I cannot sit on that person's case. That would obviously constitute a conflict of interest. I am aware that there's so many cases pending in the Superior Court that for those cases where I have to recuse myself, that will occur. But there are many other cases that will fill my docket, so I don't see that as a real concern. I mean, judges in the past have had to do that, and I will certainly follow their example.
So I'm glad you went on the road with many other cases, because that has always been our big thing in here about backlog and backlog and backlog. So using your skills and professionalism and everything that you plan to go in there with, what specific strategies would you say you'd employ to move the current backlog of cases forward? Like, what?
Obviously, it's a matter of, really applying and working hard to make sure that I stay on top of my docket, using the tickler system and other apps that help a judge to follow up on cases. And frankly, a matter of making decisions. As a practitioner, sometimes as part of this community, we also are concerned about how things are not moving as rapidly as we would like. And so should I be confirmed to this position, it certainly be my objective to make decisions and rule on cases. It's not a matter of always being quick to make decisions, but making sure decisions are thorough, that they're quality written positions, and so that every litigant and every party feels that they have been heard, represented, and the judge has not made a quick snap decision, but a well thought out and thorough and well-reasoned position. And there are cases that lend themselves to a quick decision from the bench, as I stated,
Yes.
and there are others that require more research, more diligence, a matter of writing a written decision. So again, it's a matter of being able to do that. But obviously, hard work and diligence and being committed to the task goes a long way in moving one's docket.
Good. So before the call time, let me sneak in this one here. If confirmed, what do you hope your tenure in the Superior Court will represent?
Time.
And how do you intend to strengthen public confidence in the judiciary of the Virgin Islands?
public confidence in the judiciary may be eroded if persons in our community do not believe that judges are being fair and biased, comes to the position with a level of integrity, independence, and impartiality. I possess all of those qualities I think of you have cited from the beginning. And I think my name, my reputation will help to develop and engender confidence in the judiciary. As I said, the judges in our courts are second to none. We don't have judges being charged with, any violations of law or rules or anything of that sort. And I think that's important. And I think the community has a lot of confidence in the judiciary, save, the concerns about how quickly cases are not moving.
But it's what you're going to add, Attorney Williams. It's what you're going to bring to the table.
It's a legitimate concern. I'm sorry?
It's what you're going to add, what you bring into the table.
Right. And I bring a sense of making sure that those things happen and people understand that we're making decisions that are well thought out, that's in the best interest of the community, and the law is being applied to the facts of every particular case. As long as parties leave the courtroom knowing that they've had a fair hearing, we're satisfied with that.
Thank you very much. Thank you for your responses, Attorney Williams.
Thank you so much, Attorney Williams, for those responses. I do have a follow-up question to ask based on one of your responses to the previous senator. Relative to how you are going to be able to address the backlog, what are some of the things, the techniques you think could happen? Because I know there are different techniques judges can use so that, you're not waiting for, say, an order to be issued or so that you could move things along. Are there any techniques that you can bring or utilize when you are sitting in that bench?
There are apps that one can use, and in private practice, we use the Amica system to keep track of cases and help to move cases along to show what has been done, what needs to be done. And I think we could use similar systems within the court system, and I'm sure the judges do that. Again, in terms of what I bring to it, it's my private practice experience that says hard work and sticking to it and making sure cases get heard, that cases aren't continued unnecessarily, and that individuals understand that when a court issues deadline, that we expect, lawyers to comply with those deadlines. I'm sure I've violated a couple of those myself in 40 years, but it's a matter, again, of knowing which lawyers are giving you legitimate reasons as to why they cannot comply and others who are not. And therefore, as a judge, I have to know that difference and act accordingly.
I'm grateful I asked that question to pull that response out of you, because that's a key managerial issue with managing the docket and making sure that justice, as you said, is not delayed or denied. Because we're seeing a lot of the cases, or the backlog is caused by all of these continuances for whatever reason. I'm so glad that you have a great perspective on how to manage and handle that. I'll now recognize Senator Angel Bulquez Jr. for your 4 minutes.
Thank you and good morning,
Good morning.
Madam Chair. Good morning, colleagues. Good morning to the listening and viewing audience. Good morning, Central staff. And of course, good morning to our nominee, Mr. Attorney Pedro Williams, and everyone in the chambers in St. Thomas. Attorney Williams is clearly not a stranger to us. He's very qualified, 40 years of legal experience across civil and criminal matters, and his record speaks for itself. He's served in the community, represented major public agencies and unions, and supported many civic functions that align with the quality of life. And he has a very calm and consistent power about him. And most of all, he's a man of God. and he brings a wealth and a depth of experience that I believe the Superior Court will benefit from. Good morning, Attorney Williams.
Good morning, Senator Bolkus.
Thank you for moving forward and putting yourself up for this vacancy. I have a few questions for you, and I wanted to know what qualities do you believe are most essential for a Superior Court judge, and how have you demonstrated those qualities throughout your career?
I believe the most important qualities are that of independence, integrity, and impartiality. Independence means I will not and cannot be swayed by others who are not, who are trying to influence my decision. My decisions must be based on the law and the facts of the particular case. Integrity speaks for itself. A person who has shown a degree of honesty, my word is my bond. When I say something, I mean it. I've lived a life in this community that people can examine any way they want and find that we've upheld a very high moral standard. Obviously, my first obligation has always been to God. Independence, integrity, impartiality, that I will not be biased towards or against any party, regardless of the circumstances, which brings them before the court. I suspect there are a lot of people in our community, particularly young people, who may have questions about the fairness of the judicial system, about the sentencing that judges impose, about whether or not they're being properly and effectively represented by counsels. All of those things I will have to monitor and ensure that they take place in a reasonable and prudent fashion in order for members of this community to understand and respect the role of the judiciary.
Thank you for that very good response. And, you know, I've always known you to be a person who has been very fair and impartial. And I'm assuming that is part of your core philosophy as a person. And 40 years of legal experience, not to mention what other experiences you have, is a lot. And I think that brings a lot to the table. And I just wanted to ask one last question before my time wraps up. What specific cases or any legal challenges that you're available to elaborate on do you believe have prepared you to meet the demands of a Superior Court judge?
Do I respond?
Kindly proceed. Senator, your time was called. I'm going to allow the nominee to proceed in responding to your question. Kindly proceed, Attorney Williams.
Senator Bolkus, I believe as a trial lawyer, doing several murder cases, which are very high pressured, as well as civil cases that involved multiple parties and complex issues, where one has to, do a lot of research, write a lot of trial briefs, do discovery, do depositions, and be in court for days in a trial, all the things that helps to prepare one to assume the position of a judge. One has to understand the rules of evidence, trial procedures, the rules of the court, and the rules that governs litigation. I believe I've had many experiences, and I don't know if you want me to name a particular case or cases, but there are a number of them that have helped to prepare me for this position.
Thank you so much for your response, Attorney Pedro Williams. And of course, thank you, Madam Chair, for the time. I look forward to voting at the appropriate time. Thank you.
Thank you so much, Senator Bolkes, for those program questions. At this time, the chair will recognize Senator Clifford A. Joseph for your 4 minutes. Kindly proceed, Senator Joseph.
Thank you, Madam Chair, for the time. Good morning to one and all. Good morning to the listening public. Good morning to the people here in the Borden Islands. Good morning to everybody here in the chambers this morning. Attorney Williams, 40 years experience, 40 plus years experience, 40 years being married. That says a lot.
You want to know which one was most challenging, right? No, I'm just kidding.
I along the line. I hit in the 30 mark myself, and I close to 40 in being together, so I understand. You don't have to explain that portion. But, and a clarity when it comes to yourself becoming the judge, and you're knowing so much people, like as far as your recusal, as how do you balance out? And I listened to you spoke about cases that you might have. Those are automatic. But I don't know you personally, but I've heard good things about you. Even today, sitting at the airport, coming here, your name pop up, and they didn't even know I was coming here for that. The person I was speaking to didn't know that today is your day for being here in the Rules Committee. But, he said, well, everything good about you. And then he mentioned too, your experience should take your ways. I supported young judge coming through. So for sure, when I looked at your docs and I listened to your testimony, it gave me personally a good feeling for you being on the bench, personally. But still, I like to know outside, because myself, when I go to the courtroom here and when I go to the court and St. Croix, I have a problem. I'm always recused. This one recused and that one recused, and then I have to wait again, and that's the problem we have in our judicial we have the problem with backlog, and I just use them based on my experience, and I get to court. I got a court case from a civil case from 2009. As a landlord, I get to court, and I got to listen to all the recusal, and I have to wait again for a judge to come from St. Thomas to hear a case of mine. So for me, I don't want to go to court for nothing. That's me. But not because I don't want to go to court. Other folks have to go to court for whatever reason. So my question I have for you is, outside of, so how do you face in? Like, let me share one of my experience. I had an experience at a time when the judge was getting ready to recuse herself. And the tenant turned and tell the judge, Judge, I owe this man, so I don't care if you take me from your courtroom to the next courtroom. And then she went ahead and heard the court. But I just wanted to make sure that sometime in your recusal, this is just an experience that I think that you're going to need to use because you're so popular, is allowing the person to let them know, like, hey, I know this person. Do you want me to hear this case? And not just recuse yourself. I want you to think about that. Because just recusing will make the line longer. But at least if the person know out of your honest mouth that, yes, I know this person personally, and do you want me to hear this case? Or else I could move it on to our next judge. Because sometimes you're going to run into that on the day when the court call. You got me?
Sure. Senator Joseph, the point you've made is I understand. The rules of judicial conduct provides that, aside from the issue that you raised, that if there's a conflict, I can always ask counsels to waive the conflict.
Okay.
And if both of them agree that I can be unbiased and impartial in hearing and rendering a decision, then that would address that issue so that there would not be a delay in the matter. So there are ways around it, and there are ways to address it in order to move the case. And obviously, one would want to look at the docket beforehand and frankly be able to determine whether there are conflicts or potential conflicts and maybe address those before the case is scheduled to be heard. And that way, litigants will be placed on another judge's docket, or at least we could get the consent of the parties prior to the court proceedings, so there'll be no interruption. So there are ways to address those concerns.
Madam Chair, could I want one more question, please?
You may proceed, Senator.
Okay, so in your enlightenment, what would you consider to be the most important quality of a good judge?
I'm not sure there's any one particular quality, and at the risk of sounding like a broken record, what I indicated, I believe, to Senator Bolkis's question is that of independence, integrity, and impartiality. I think those are the three hallmarks of an excellent judge.
Well, I just want you to repeat it so I know that you're on. Well, thank you. Thank you for your response, and thank you, Madam Chair.
Okay. To the audience, and should Attorney Williams be confirmed here today, he's going to sit in a position of judgeship that I am sitting. We are having a proceeding. So I know that I've been a little bit relaxed with the decorum, but I'm just asking you to just quiet it down and respect the chambers, okay? Just have that level of respect. I was trying to make sure I am not so rigid for 2026, not so rigid and relaxed, but don't go over that boundary. Just be a little quiet so we can have this proceeding, because do recall, we have a stenographer who is also recording this proceeding, and this is a part of the record, and we don't want to have it skewed and have her miss any part of the proceeding. So I would just ask you to practice that self-control. Senator Milton E. Potter, Mr. President, you are recognized for your 4 minutes.
Thank you very much, Madam Chair. Good morning, colleagues. Special good morning to my friend, Attorney Pedro Williams. We go way back. I think both of our mothers were Margarets with connections to Antigua. So I know your mom will be proud to see you here in this position today. But I still ain't gonna take it easy on you today, Attorney Williams. I wanted to really start by asking you to describe a situation in your practice where following the law led to an unpopular outcome. And how did you handle public or client pressure in that moment?
That's probably a difficult one. If I go back to maybe one of the arbitration cases we did for a firefighter, he had an issue relative to wearing locks and whether or not he was suited for the position. The government took the position that he was not, terminated him, and we had to fight that matter in arbitration. And while the government and others may not have been quite happy with that, and maybe some members of the community, we believe that those firefighters were certainly entitled to their position, because they had nothing to do with the quality or the ability to do the job. Again, this goes back years when there are certain prejudices or certain lifestyles that were not particularly within the normal, acceptable culture. And so I think that was one of the cases that we did that we felt happy about. It may not have been a popular decision, but it was certainly a right decision.
Understood. Appreciate that. What prior experiences best demonstrate your ability to manage a tense courtroom or a disrespectful attorney while maintaining decorum and fairness?
Senator Potter, I would say, having been a litigator and arguing with other lawyers in the courtroom, being interrupted by other colleagues and having to assert, I am speaking. This is my turn. Do not interrupt me. people who know me would know I have no problems asserting authority, making people know who's in charge, and having people to comply with those directives.
Excellent. I believe if you are confirmed, and I have no doubt that you will be confirmed to this position, you, and I was thinking about it last night, you will be the only male judge, correct me if I'm wrong, in the St. Thomas, St. John district of the Superior Court. Is that true? Would
That
be
is
true?
correct, Senator Panel.
Any thoughts on that? It's amazing to me that we have had
30 seconds.
0 male judges in the district for such a long period of time. Any thoughts on that? And how does that impact, if any? I mean,
At our board meeting in December, I believe Attorney Miller was commenting on the fact that when he first came to the VI many moons ago, they were all male judges in the district or in the division.
turn around is fair play. that's what you
We've come full circle, but obviously, if I'm confirmed, that would start to change that a little bit. Maybe get more of a balance. But I frankly don't think that whether the judges are male or female is really the determinative factor. We certainly have good lawyers in the territory who could always be good judges. As I said in my prepared statement, we have great judges in the territory. And whether they're male or female, I think they've done well in ruling on cases, making decisions. I believe the judiciary has the respect of the community. And it just depends. I mean, sometimes individuals don't make themselves available for these positions, so that may be a factor in why we've only had female judges in the St. Thomas, St. John district. But again, I don't believe one sex is determinative of one being a good judge.
I appreciate your response. Attorney Williams, I characterize your tenure and your presence here in this community, both as a lawyer and just as a resident in the territory,
Time.
steady, consistent, and engaged. Nobody can't say that you just, do your law practice, go home, relax, and take it easy. You are engaged, you're involved in your church, in the community, in the political structure. And I think it says a lot about you, your character, and who you are. And at the appropriate time, I have no doubt that my vote will be yes, and I have no doubt that you will be confirmed to this position. Thank you very much, Madam Chair.
Thank you so much, Senate President. I want to follow up on a question, and this goes to your jurisprudence and your theory of how you are going to be able to administer justice when you are sworn in as a judge. I'm going to speak it into existence. What steps would you take to assure fair access to justice for your litigants, including those who are representing themselves and even our indigent population? Because that's one of the things. I remember the Lieutenant Governor, in his remarks, he mentioned that under Judge Hodge leadership, there would be documents that they would have available to the layperson so that they could represent themselves and not have to, because they may not have that money, so that they could just fill out forms and just submit it, because that's sometimes what it takes. So what do you see that can happen so that that layperson could actually have that level of justice for themselves and be able to advocate it for themselves in the court?
Senator Joseph, for those who qualify and haven't served on the board for legal services of the Virgin Islands, of course, legal services does a tremendous job in representing indigent individuals or persons who cannot afford counsel, but they're overwhelmed.
Yes.
and they can't do everything. I heard the Lieutenant Governor saying that at the swearing-in, well, not the swearing-in, the renaming ceremony for Judge Hodge for the court. And those are practical things that can be done where individuals who are appearing pro se can have forms and documents from the court that they can simply complete. They know what to do, etc. But I think one of the things that maybe we've lost a little bit of sight on in this community is the judge being able to call up a lawyer and say, you know, I have a person in my courtroom who really needs counsel, but they can't afford it. Would you represent this individual? And it doesn't mean that the judge is going to rule in that person's favor simply because they've asked a lawyer to do it. And frankly, I think most lawyers would agree to do that because I think most lawyers also understand their responsibility and service to this community. I mean, they don't want to do it every day, but I think, you know, a couple of cases like that a year, you know, spread among members of our bar would certainly go a long way. You know, no pressure, but at least just making the request because they're individuals who need justice. And we know that they're not, and particularly if there's a lawyer on the other side, they're at a severe disadvantage. Frankly, I hate to try cases with pro se litigants because it just, you know, takes more time and you have to educate that person about what needs to be done. And we talk about delays in the system. That's also one of the reasons that causes delays. So if there are, you know, lawyers on both sides, it tends to make the system and the process go a lot smoother.
Thank you so much for that very informed and educational explanation. At this time, I recognize Senator Marvin A. Blyden for your 4 minutes.
Thank you so much, Madam Chair. Good morning to my colleagues, listening, viewing, audiences, staff, central staff. Good morning, Attorney Pedro Williams.
Morning,
And good morning to all of the supporters behind you. And blessed New Year's to all. And please be succinct with responses because I have about 30 questions here. But I'm not going to ask all, but 4. Let me ask you a question for real, on a serious note. Because I know you have 40 years plus experience. You have worked in different areas to include private practice. And you're well-versed working on different boards, etc., representing individuals. So can you describe a case or ruling from your tenure as an administrative law judge that illustrates your approach to applying statutes and weighing evidence impartially?
My tenure as an administrative law judge was limited to serving at the Department of Labor, unemployment claims. And in those situations, they had to do with individuals who were appealing a decision made by staff at the Department of Labor. And in many of those cases, you had the employer indicating that the person should not be entitled to unemployment benefits. I believe, without having reviewed the record, that in most of those cases, we did rule in favor of the claimant because we believe that the unemployment laws were there and put in place to help persons who are in transition period, who had been terminated from their positions unjustly, and who needed those funds in order to make, to pay and support themselves on a daily basis.
Okay, very well. Thank you for that. So what would you describe as the most important asset that you bring to the Virgin Islands judicial system? That's a question for you.
Question and the response would be the same, but just to shorten it, I would say my level of integrity and reputation in this community. Without at the risk of sounding obnoxious, it's just a matter of, I think people know and understand that I'm fair, that I'm a man of integrity, that I can't be bought, and whenever I make decisions, it'll be based on the law and the facts.
Okay, very well. And we see what's happening in Minnesota right now, right? So let me ask you this question. How would you describe your judicial philosophy, particularly when balancing government interests against individual rights?
That's always an important issue because government interest is presumably representing all the persons, including the individual who is brought, I'm assuming, an action against the government. And so as a judge, we always have to take those things seriously and balance that in order to make sure that the government is not trampling upon the rights of individuals, because that's important. We have to recognize and respect the Constitution and the revised Organic Act of Law of the Virgin Islands. And so those things have to be looked at in total. They have to be balanced.
30
And I
seconds.
think, judicial decisions generally show judges wrestling with those issues and hopefully more often than not coming up with the right decision.
Okay, very well. So what is your view on judicial activism versus judicial restraint? And where do you see yourself on that spectrum?
I don't think that judges or legislators or executive officials, judges interpret and apply the law. And while there may be decisions where a decision may be characterized as a judge being an activist, I think in most cases the judge was simply writing a decision that explains a position and writing a decision that gives people guidance for future actions and activities. If one characterizes that as judicial activism, so be it. But I don't think most judges intend for that to be the case or for their decisions to be interpreted that way.
And may I ask one more question, please, Madam Chair?
Yes, you may proceed, Senator.
Okay, very well. And being that you're deeply involved in the church, you're part of the clergy, let me ask you this question. Based on your faith, all right, how do you ensure that your personal religious beliefs do not influence your interpretation of the law or your decisions when it comes to the bench? Because I know at times I may have struggles here making decisions based on my beliefs, but what's your take on that and how will you proceed in that realm?
Senator Blyden, in 40 years, my faith has guided me and helped me to make decisions in everything that I've done. That's not going to change. I think it's that faith that will enable me, with the help and the wisdom of God, to make right, fair, just decisions. I can't imagine, and obviously I've given that a lot of thought, that there'll be any decisions that will conflict with my faith. As a judge, my job is to interpret and apply the law as it exists. And I may not even like the law that the legislature has passed and put in place, but my job is not to determine whether it's a law that I like or don't like. My job is to interpret that law and apply it to the facts of the particular case and come up with a decision. If that law has to be changed, that's a responsibility for this body, not for the courts.
Very well. Thank you so much for your responses, Madam Chair. Thank you for the extra time. Thank you.
Thank you so much, Senator Blyden, for raising that question. That was one of my questions I was going to raise. And I wanted to ask you, because, of course, we have our Constitution of the United States. And there are written in the Constitution certain rights that we as citizens have. And sometimes I see those rights, and I know that you mentioned in your response to the previous senator that government shouldn't be trampling on persons' right, their rights under the Constitution. Our rights under the Constitution, do we have, as Virgin Islanders, in your perspective, rights under the Constitution? Are all of the rights under the Constitution of the United States carried, extended here?
Madam Chair, I'm not sure what you're driving at, but clearly most of the U.S. constitutions do apply to us here in the Virgin Islands.
Most, but not all.
Most, but not all. There may be a few exceptions. I mean, if you're trying to get into the whole insular cases, I'm not sure we have the time to debate
I'm not going to
those
go.
issues.
I'm not going to debate that. That's
but-
another fight.
But I think for what most citizens need in terms of rights, those are applicable to us here in the Virgin Islands. The right to due process, freedom of speech, religion, etc. I think those rights are important to 99.9% of the populace do apply here in the Virgin Islands.
Okay, thank you. And that is exactly what I wanted to make sure. And that is answered, that we are very clear that we do have those constitutional rights. We do have a battle with one right, and that's a bigger battle. At this time, I'll recognize Senator Novell E. Francis Jr. for your 4 minutes.
Thank you very much, Madam Chair. Good morning to you. Good morning to my colleagues. Good morning to the central staff. And good morning to the governor's nominee, Attorney Pedro Williams, as well as good morning to the people of the Virgin Islands. I first want to take this opportunity because of the discussion that we're having this morning in respect to pro bono work, as well as to the judiciary, to offer my condolences to Attorney Ezra Winter's family and his passing this week, and really to also thank Attorney Williams for his willingness to serve in this critical position. I want to say that I truly believe that in my 37 years of government service, I've had many interactions with Attorney Williams. I think he's a career devoted public servant, a steward of good trust, and certainly possess the fundamental traits to be a judge. He has the integrity, character, fairness, temperament, and certainly he has the experience. I wanted to ask you, though, that of course, experience matters, but I wanted to ask you that I've heard in my time out being around here for many years that you have been asked before to serve in this capacity as a judge. Why now?
My wife gave me the clearance.
A good answer.
Honestly,
A good answer, certainly.
More seriously, Senator Francis, I think as I looked around, that having practiced for 40 years, I thought it would be a good change in my career path to pursue the bench and to serve this community in a different capacity. When I said my wife gave me the clearance, that is a true statement and an important one, that I can make this change because it will affect our quality of life as a family. But it's just another opportunity to serve this community that I love and respect.
Very well, thank you. So, along with also thanking you, I want to thank the wife for allowing you to serve in this capacity as well as your family. Obviously, we all have strengths and weaknesses. Can you speak to two of your strengths that you draw upon on a daily basis, and just one weakness that you believe that you'll have to undertake in terms of improving?
My strengths, Senator Francis, would be my faith and my commitment to God that governs my moral compass. My other strength would be that I'm an overachiever and a hard worker. Many folks have told me that I'm doing too much, that I need to slow down. And I tell them, I don't know what that means. People ask me, when am I going to retire? I have no idea what that concept means. As long as I'm here to work. And that's what's going to happen. And that is also my weakness, is that I don't know how to slow down and how to take it easy. Even when we're on vacation, there's always things to be done.
Very well. In terms of the issue of
30 seconds.
backlog of cases, it is something that's real and something that's often brought to my attention as a people's representative in my various positions. Can you again reassure this community how you intend to undertake the issue of backlog? Obviously, we know that there's some structural indifferences that present some challenges there, but in respect to your innate responsibility, can you speak to how you intend to continue to move your case and your load forward?
Again, as I indicated, it's a matter of being familiar, having studied the cases, being able to make decisions even from the bench when a case has been fully litigated. It's also writing and issuing written decisions in a timely fashion and being able to determine whether or not lawyers or litigants are trying to delay the court proceedings. All lawyers or litigants are entitled to some continuances as long as there are legitimate reasons to do so, but one should not take advantage of the system or those opportunities, and a judge has to be able to tell the difference. I believe, applying and utilizing some of the technology that's available to help to move cases, keep track of cases, make sure cases aren't lingering, and be able to have, good, competent staff, meaning law clerks and others to assist in that process. I believe those are some of the ways in which cases can move a little bit more efficiently.
Thank you for your responses. I'm not a member of this committee. I don't have a vote on this committee, but certainly when it comes to the full session, I'll be making my vote. I truly believe that I wanted to come and lend my voice because I truly believe that you're a Renaissance man, and you have your record marked with reliability, duty, and accountability. So again, I want to thank you and your family for what you're doing here in this undertaking. Thank you very much, Madam Chair, for the time and opportunity.
Thank you so much, Senator Francis, for those probing questions. At this time, we will recognize Senator Alma Francis Heiliger for your 4 minutes. Kindly proceed.
Thank you. Good day to my colleagues. Good day to the people of the territory. Good day to my colleagues. Good day to the people of the territory. Good day to Attorney Williams, everyone here in the audience. First of all, I would like to say Happy New Year. I hope everyone brought in the new year with blessings, and I am excited about 2026. My first statement I want to say is that, a lot of times the people or some feel that I'm always in disagreement with the governor. And I tell them, no, I am a senator that believes that if he does something I don't like, I will say so. And if he does something I do like, I will say so. And this is one time he got it right. So I'm happily giving him kudos today because when I saw that you were nominated, I was very, very happy because as a person born and raised in this community, sometimes we don't always say things, but we pay attention. I follow people. I watch what people are doing, how they function. I get to the point where if I know something happened to me, what lawyers are you going to find? And you are actually on my list. So that's a plus for you. But thank God, I've never been in any situation that I needed one. So that's a good thing. But my first set of questions I want to ask is, sometimes you're in situations where the law is ambiguous. And you have to figure out a way how to deal with that. What are your thoughts in potentially dealing with a situation where the law is kind of open-ended? How would you handle a situation like that?
Senator Heiliger, as a practitioner, I will tell you those are probably the best kind of cases where the law is not particularly clear, but as a litigant, you get to utilize your skills, your abilities, your creativity to try and frame an argument in front of a judge as to why the judge should rule in your favor. And the judge takes all that into consideration. But then on the other hand, as a judge, again, it gives you an opportunity to really write a decision where you have to get into the meat of the matter. You have to weigh the pros and the cons and look at all sides and really do the research to see, what precedents has determined in this or similar situations or areas, and come up with a decision in which you're saying that, there are no precedent cases to guide me on this, but here's a decision, and hopefully you've written a good decision that other judges will then look at to say, yeah, I can follow that decision. It makes a lot of sense.
Excellent.
So those are the best kind of cases, to be honest.
Good. I'm happy to hear that. The other question I want to ask has to do with, as human beings, we have our own biases. We live in a society based on how we interact. We're around a particular group or environment, and we're raised with particular biases. And as a judge, I know you spoke about handling situations and integrity, but sometimes there are some situations that are so near and dear to us. I can't imagine when it's a judge that have to make a decision. How do you strip
30
yourself
seconds?
from that and just leave yourself open to the facts of the case and really remove those biases altogether so you could render a fair and impartial judgment?
Again, as a litigator, we've been in situations in the last 40 years where we've had to do exactly what you're suggesting. I've been appointed to represent individuals who have committed a crime that I don't particularly want to represent. But it's my duty and my responsibility to do that. Or a client comes and they hire me to do that. Even as a judge, while we all do have some inherent biases, my responsibility is to put those biases aside and not allow those biases to cloud whatever decisions I'm being asked to make. And if it ever gets to the point where I'm unable to do that, then that's a case that I need to send to another judge. I cannot and will not compromise my integrity, my character, or even the integrity of the court by ruling on something that I have a particular bias for or against.
Oh, thank you so much for that response. Madam Chair, may I ask my final question?
You may proceed, Senator.
Thank you. One of the things that I see here, because we live in such a small community, I understand political pressure. I understand sometimes when you hear the voice of the people, they literally sometimes take decisions of judges personal. And I understand that as a judge, you have to follow what the law dictates. And I know you spoke a little bit earlier about situations potentially like that. But do you think that, what do you think about situations like that occurring where you might have rendered a decision that is so publicly unpopular because based on law, you had to go in a particular direction? But do you think societally, do you think that sometimes laws that force a judge to go in a particular direction, is that an opening for us to potentially speak to the legislature or how to improve on certain things? Because there are some laws on the books that might have been good 20 years ago, but for a judge to have to be forced to rule in that particular direction, it might not suit the society at this time. What are your thoughts about dealing with stuff like that?
The reality is that once a judge makes a decision, at least in the Superior Court, there are appeal processes. One could certainly appeal to the Supreme Court of the Virgin Islands. So that's one avenue. Again, a judge is not making decisions because it's popular or because he's going to be called a good judge or somebody's going to like him for that decision. A judge makes a decision based on the law and the facts. And if, as a judge, I make a decision that the legislature as a body does not particularly like, then they certainly always have the right to amend the statutes or law to do something differently.
Well, could I just make my last statement quickly? I wasn't speaking so much about the legislature not liking something. I'm talking about time and what might be good in one time versus another time as we advance as a society. Is that something where a judge might reach out to the legislature and say, hey, you guys might need to look at this section of the code? Or how do you guys deal with stuff like that? Because it might put y'all in a situation to follow that law, but it might be so antiquated, it might not have rendered, in your opinion, what might have been the best judgment.
I don't know that it's appropriate for a judge to reach out to the legislature and say, hey, you need to take a look at, Title 24's, section, whatever. It would seem to me that the legislature has a legal counsel's office that monitors and looks at things that are happening in the judiciary. And if there are needs for statute to be looked at, to be amended, new laws to be enacted, then it should be your legal counsel's office that guides that process. I don't think it's appropriate for the judiciary, because then you'll have 10 different persons say, hey, look at these laws. I'm not sure that that's the direction that I would want to advocate.
But thank you so much for your response. Madam Chair, I appreciate the additional time, and you definitely have my support, because I think you would make an excellent judge and serve the people of this territory. Thank you so much, Madam Chair.
Thank you, Senator Heiliger.
And thank you so much, Senator Heiliger, for those questions. I have just a few questions, because most of my colleagues have asked pretty much some of the questions I would have asked, and I am also asked some of the questions that I had there based on my colleagues' questions. Now, this is a question I posed to another candidate in our discussion, in our interview sit-down that I had with you also, and I have with, if not all, most of the nominees that the governor sends down. And I want to just take the opportunity in thanking you for saying yes to the governor for this position, and also thanking your wife and your family members for saying yes, and to be there to transition you when you assume and get sworn in on this position. Do you believe, how would you handle items that come up before you as a judge that can be ordered from the bench? Because, we are able to see a lot of rulings. And sometimes here we see persons, the litigants, waiting for these rulings to be penned out, and they sometimes are very lengthy. Do you think it would be wise, and based on your jurisprudence, to rule from the bench in some instances, or do you prefer, just in your work ethics and your modus of operandi, to rule in writing all the time, and so that your persons will have to wait until you issue that order for it to be carried out?
Madam Chair, I believe it's appropriate to do both. As I indicated, there are cases that are ripe for a decision from the bench. You have a 3-hour hearing, a trial, and the issues are straightforward. For example, there's a contractor breach of contract dispute. The party paid the contractor to build a house. They didn't do it. They didn't comply with the terms of the contract. It's easy to rule in favor of the plaintiff. Now, calculating damages may take a little bit longer, but at least the parties know where the position is. There are situations, as Senator Heiliger indicated, where the law is unclear. That's a lot more involved and more complex, that requires sitting down, reviewing transcripts and writing a decision that takes days, weeks, months of research and, writing drafts of opinions. So it varies. But again, judges understand what position each case is, and a judge can do both in order to move cases along by ruling from the bench, and others you may have to write a written decision.
Okay. Now, I typically ask these questions of all nominees, and I know that you are leaving a very vibrant and robust practice. Over 40 years, that's a lot of time. How do you see your ability to transition from private practice into now to become a judge of the Superior Court?
I think one of the advantages I have in that transition
30 seconds.
is that I'm not a solo practitioner. I am in a firm. My son is there as a partner. The firm will continue. Others may be brought in to assist as necessary. Clients will have the opportunity and the right to take their cases to other lawyers if they don't want to stay with the practice. My sense is most of them will remain. So there will be no lag in terms of clients being able to be properly represented. And I'm sure if they're not, then they're going to call me and tell me my son isn't the father. He's not doing as good a job, but I don't anticipate that that's going to happen.
Okay, good. Because we wanted to make sure that that transition isn't something that's difficult, but I know if you said yes to this position with your wife's consent, that you would be amply prepared to do this. Do we have any other senator that has a burning question? Senator Clifford Joseph, you're recognized for your burning question.
Okay. In the community, we have individuals awaiting trial, additional crime allegedly. How would you balance public safety with the defense rights and their presumption of innocence?
That's always a challenging and a difficult position. Again, a judge has to balance those factors. One is that in a criminal matter, all defendants are presumed innocent until proven guilty. Bail or denial of bail should not be punishment for somebody who's not been convicted of a crime. I was telling somebody the other day, one of the things that happens is that sometimes members of the community say, you need to keep the person in jail, don't give them bail. I tell people that ought to be viewed in the context of if that were your son or brother or uncle, what would you want to happen to that person? It's easy to say that when you don't know the individual, but when it's a family member, and again, he didn't do the crime, he didn't do anything. So again, one has to balance that, and most defendants are entitled to at least one opportunity of bail to get out to do that. Of course, if they violate any of the terms and conditions of their bail, then that's a whole different matter, and then the person will sit in jail until the case is tried. If there's evidence that the person is, in course, a danger to the community, there are ways of monitoring that individual, and a judge can, put some certain terms and conditions in place in order to protect, provide for public safety. But clearly, our job as judges would not be to endanger the public safety, but to be able to achieve that balance so that members of the community understand that what their rights are and the public as a whole is protected from criminal elements.
One more.
You may proceed, Senator. We'd wrap up.
I noticed in the questionnaire you had a situation where you had a failure to represent and for the due process, but I know if you can play something on the record, maybe explain outside of that particular case, the due process violation mentioned in your questionnaire.
Well, so just to make the record clear, there was an allegation of failure to represent. I represented the individual as a member of the union. This was her second offense. The first time she was suspended for a different issue. Second time she was she was terminated. The government made an offer to put her back, and the terms and conditions that should she violate any terms and conditions and she was a correction officer, that she would be terminated without any recourse. The union representative and myself explained what that meant to her, and collectively we agreed that she would not accept the offer with those terms and conditions. Went to arbitration. We lost the arbitration. Somebody mentioned earlier, she hired Attorney Winter to represent her. He brought this claim, and the matter had languished for about 13 years before the courts. I'm happy to say that the matter has been settled and resolved, but the case law, as I understood it, is that she would not have won for failure to represent claim against counsel, because the only party that she would have a claim against would be the union.
Well, thank you for your honesty again. You see how important that first answer was? It come right back in circle. Anyway, I'm in support of your nomination, and thank you for accepting the nomination, Attorney Williams.
sir.
Thank you, Madam Chair, for the time.
Thank you. Before the motion, I wanted to ask one question regarding this whole, I understand. I wanted to ask a question pertaining to the issue of Office of Disciplinary Counsel, because that's one of the things that we're having some little challenges here with. And the previous senator brought up an issue that came up. Do you see yourself having to be in an element of disciplining other bar members should you assume this position, when you assume this position as judge?
Well, I don't believe that as a judge it's my role or responsibility to discipline other members of the bar. There's an Office of Disciplinary Counsel for that matter. There are programs that are available if lawyers have issues to the Bar Association. But I do believe, though, that as judges, if we see situations where we see a former colleague or member of the bar who are having challenges, who's not appearing in court prepared, I don't have a problem in calling that person aside and speaking to them as person to person and expressing my concern and see whether or not there are things that we could do to assist that person. Because we're all human beings, people have challenges. You don't know what people are dealing with, and there's seasons in persons' lives where things may not be as well as they once were, and just a decent human element. If you see something that you know isn't right or shouldn't be happening, then there's a responsibility to bring it to the person's attention. If they don't deal with it, or then you may have to take it to a higher level. And frankly, those would be our responsibilities as part of our code of judicial conduct.
Thank you so much, and I do want to recognize the motion, but I wanted to get that question in because it's very critical. It goes towards what you stated about compassion and humility and the patience to be able to have those discussions with persons, not to pull them down, but to definitely, work with them as human beings, because we all are human. I did hear a motion on the floor. I want to recognize that. Mr. Secretary, you made a motion.
Madam Chair, my motion one.
I know. Let's go. It's
All
for me
right.
to recognize. Go ahead.
I don't want the judge have to make a ruling already, but anyhow.
And it'll be my favor.
Madam Chair, I move that the governor's nominee for judge of the Superior Court Division St. Thomas St. John, Mr. Pedro Williams, Esquire, be voted upon favorably in this committee of Rules and Judiciary and forwarded to the full body for further vetting and action. I so move.
Thank you so much, Mr. Secretary. The motion to favorably move Mr. Pedro Williams, Esquire, Governor's nominee for Judge of the Superior Court of the Virgin Islands Division of St. Thomas and St. John has been properly moved by Senator Avery Lewis, seconded by Senators Milton E. Potter, Clifford A. Joseph, Alma Francis Heiliger. Roll call on the nomination of Attorney Pedro Williams, Esquire, to Superior Court Judge of the Division of St. Thomas, St. John.
Senator Angel L. Boques Jr.,
Yeah.
Senator Bocas Jr., yay. Senator Kenneth L. Gittens. Senator Gittens, absent. Senator Alma Francis Halliger. Senator Francis Halliger, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis. Yes. Senator Lewis, yay. Senator Milton E. Potter. Yes. Senator Potter, yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. Governor's nominee, Attorney Pedro Williams, for Judge of the Superior Court of the Virgin Islands, Division of St. Thomas, St. John, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Thank you so much. At this time, we will allow Attorney Williams to present 60 seconds closing remarks. Kindly proceed, Attorney Williams.
Thank you, Senators, for this opportunity, and thank you for your vote of confidence. I appreciate it, and I look forward to serving this community in my capacity as a judge of the Superior Court of the Virgin Islands. Thank you, and God bless.
Thank you so much, Attorney Williams, and if the audience want to applaud, you are free. I'm going to allow you. Thank you, thank you, thank you so much. The committee stands in recess for 10 minutes.
Hey!
And the Committee on Rules and Judiciary is back on the record. Madam Clerk, kindly proceed with reading Block 2 of today's agenda into the record.
Block 2, Bill Number 36-0134, an act repealing and reacting Title 18 Virgin Islands Code, Chapter 1, Section 2, relating to government employees' eligibility for elected offices to allow government employees to run for political office while actively employed, unless specified, prohibited by federal or other laws, proposed by Senator Maurice C. James. Invited testifier, Ms. Cindy Richardson, Director of the Division of Personnel. Madam Chair, this concludes the reading of Block 2.
Thank you. We are going to take a... Okay. Just making sure we are covered with the stenographers, because I know that they are typically remote, so just making sure. So thank you so much, Madam Clerk, for reading Block 2 into the agenda. We have before us this bill that was voted upon in the Committee on Government Operations and Veteran Affairs, and Bill 360134, and here to render testimony because she was unavailable when this bill was considered in the Committee on Government Operations, Veteran Affairs, and Consumer Protection is Director Cindy Richardson. Happy New Year to you, Director Richardson, and your team that are gathered here. Kindly proceed with first, let's do some mic checks to make sure our mics are working, and state your name for the record.
Good afternoon, Cindy Richardson, Director, Division of Personnel.
Good afternoon, Florine Odin Hassel, Assistant Director, Division of Personnel.
Good afternoon, Aliyah Felix Blyden, Legal Counsel, Division of Personnel.
Thank you, ladies, for being here and for joining us today. Director Richardson, kindly proceed with reading your submitted testimony into the record.
A pleasant good afternoon and Happy New Year to Honorable Carla J. Joseph, Chairwoman of the Committee of Rules and Judiciary, members of the committee, non-committee members, and the viewing and listening audience. My name is Cindy L. Richardson, Director of the Division of Personnel. Accompanying me today is Assistant Director, Ms. Florine Odin Hassel, and Legal Counsel, Aliyah Felix Blyden. I appreciate the opportunity to submit testimony in support of Bill number 36-0134. Bill number 36-0134 is an act repealing and reenacting Title 18 Virgin Islands Code, Chapter 1, Section 2, relating to government employees' eligibility for elected offices to allow government employees to run for political office while actively employed, unless specifically prohibited by federal or other laws. This bill represents a meaningful and necessary step toward ensuring equitable access to public service for all government of the Virgin Islands employees, while maintaining essential safeguards to protect the integrity of government operations. The Division of Personnel previously testified in support of the prior iteration of this legislation, Bill number 35-0032, during the 35th legislature. We reaffirm our support of this measure as reintroduced and amended, recognizing its alignment with DOP's obligation to ensure fair, consistent, and equitable employment practices across the government service. As a human resources entity responsible for administering personnel rules, classification, and benefits of all GVI employees, the Division of Personnel supports legislation that promotes fairness and accessibility in public service while maintaining safeguards that preserve the integrity of government operations. Bill number 36-0134 modernizes an outdated framework that has historically discouraged or prevented employees from seeking elective office due to financial hardship and restrictive leave policies. The measure ensures that employees may participate in the democratic process without forfeiting their livelihood, while clearly delineating boundaries to prevent conflict of interest or misuse of public resources. The previous version of this legislation, Bill number 35-0032, permitted government employees to seek elective office without being forced to take an automatic leave of absence. It also allowed supervisors to require leave of an employee's campaign if an employee's campaign interfered with the official duties. The current version, Bill number 36-0134, strengthens and simplifies that framework by removing discretionary leave determinations and making clear that government employees may remain in active employment status while running for office unless prohibited by federal law. The amended bill further clarifies that judicial officers and law clerks are excluded from coverage under this section, as their conduct is governed separately by the Virgin Islands Code of Judicial Conduct and the Code of Conduct for law clerks. It also refines the provisions related to the boards of education and elections, confirming that employees may seek election to these boards but may not serve as both an employee and a member of the same board simultaneously. Importantly, both versions preserve critical restrictions that prohibit campaigning or political activity during working hours and the misuse of government time, property, or authority for political purposes. Moreover, the amended version strengthens the compliance language by explicitly referencing federal restrictions under the Hatch Act, ensuring consistency with federal and other applicable laws. While DOP supports the revised language, several implementation matters warrant administrative attention. The division will issue guidance to agency heads clarifying permissible and prohibited political activities during work hours and the appropriate handling of potential conflicts of interest, recommending a communication and training campaign to ensure uniform understanding among employees and supervisors once enacted. Notably, the admission of explicit managerial requirements in this bill does not diminish agency authority to address performance, conduct, or conflict of interest. The GVI Code of Conduct, personnel rules and regulations, and relevant agency disciplinary procedures already grant management the authority to take corrective or disciplinary action when employee conduct compromises operational efficiency or government integrity. As such, it was unnecessary to duplicate these provisions in the statute. The legislation appropriately focuses on ensuring equitable access to candidacy while relying on existing management framework to uphold ethical and operational standards. Although the bill allows all government employees to remain in active employment status while seeking elective office, DOP recognizes that administrative guidance will still be needed for employees who ultimately assume elected office or voluntarily choose to take leave to campaign. These considerations relate to post-election or voluntary leave scenarios rather than candidacy itself, and ensure that employees and agencies understand how such transitions may affect employment status, retirement credit, and benefits. Bill number 36-0134 represents a meaningful modernization of Virgin Islands law. It removes unnecessary barriers to democratic participation, safeguards ethical standards, and ensures fair treatment for government employees seeking elective office. As the Central Human Resources Authority for the Government of the Virgin Islands, the Division of Personnel supports this measure and stands ready to assist the legislature and executive branch with implementation of related administrative policies. My team and I stand ready to answer any questions the committee may require. Thank you.
And thank you so much, Director Richardson. Now, the chair was going full speed ahead, and I did not ask the proponent of this measure to introduce the bill. So forgive me, colleagues. The chair will now recognize Senator Maurice C. James to please introduce Bill number 360134, and we will allow you to do that at this time. And colleagues, forgive me for jumping ahead of the gun.
Thank you. Thank you, Madam Chair. Good afternoon, Virgin Islands. Good afternoon, colleagues. Good afternoon, testifiers. Good afternoon, Central staff. And of course, all the people of the Virgin Islands. On a somber note, before I start, I want to extend my condolences to the family and friends of attorney Ezzy Winter. I was one of his mediators of choice, and so I had the opportunity to work with him whenever I was chosen to mediate his cases. And so I will miss him as a colleague of the bar. My legislation is clear and unambiguous. Simply, it allows government employees. There are certain exceptions, for example, the Judiciary branch, but it allows them to run for public office without having to take leave. I also want to point out at this point that for some reason there was a lot of smoke around the Hatch Act when we did the vetting in the Committee of Jurisdiction. And it's a little amusing to me because the Hatch Act speaks to federal employees. This is about Virgin Islands government employees. And under the Hatch Act, you have to resign to run. This isn't about resigning. This is about taking leave. Interestingly, and I will mention the Hatch Act only because in recent times we've seen a relaxation on the federal level where even employees in the District of Columbia, if they run as independent candidates and they're federal employees, they're allowed to run. So there's been a change, and I was very happy to see that the testimony talked about the outdated framework that historically discouraged employees from running, because that's in the past. And where we're seeing the federal government that people keep wanting to rely on the Hatch Act is moving away from this draconian idea of stopping people from running, which is basically gatekeeping, if we want to call it that, right? We only want certain horses to get out of the gate. So this is what's interesting. The majority of my career, I have worked as a private attorney. And when I ran for public office, taking leave was not an obstacle for me. So I was not aware of this requirement at all. It was only when I was sworn in January of 2023 that a colleague spoke about the requirements of having to take leave and a hardship that it created on my colleague of having to max out credit cards and use leave and all those things, that I said, wow, that's unfair. And you know what? I will propose legislation. And I did. And it didn't go anywhere in the 35th legislature. What I really want to focus today on, though, is that We have heard departments and agencies over and over again during the past few years talk about the shortage of employees to do work. So if we're going to focus on the fact that we have a shortage of employee, why would we want to discontinue an employee from being on a job producing for the VI government simply because they have chosen to run for political office, for public office? We can't say, you know, we need work done, but on the other hand, it's okay for us to not have people on the job simply because they're running. So, plain and simple, you either want employees to run without having to take leave, or you want them to take leave. You don't have to give any other excuses about why this, that. Simple. Let's not talk about, someone talked about continuity of operations the last time, but continuity of operations means not requiring them to take leave. Because the minute you require them to take leave, your argument about continuity of operations has gone out the window. Let's not talk about, like I said before, the Hatch Act. Let's not even try to distinguish ourselves as senators and elected officials from the other government employees, because quite frankly, in some states, we are not even full-time employees. We're part-time employees. Think about that. So when I heard that, oh, well, the legislature needs to be on the job all the time, present all the time, that's not even so when you look at other states. So let's not even use that as a reason why we are different than any other government employees in the sense of we have to be here, because all that has to happen, that happens in other states, is the governor of the state calls the legislature into a session. So there were so many things I listened to, and I understand my colleagues' concern about because I was in the federal government as a military member, and I knew that there was no way for us to use government property, government resources, or government time. And that is still the case with the Virgin Islands government. Even if you are not running for public office, you cannot use government resources, government time, government personnel for campaigning. It's against the law. And it's a misuse and abuse of public funds. And we all need to admit that. And you know, this year, the 2026 is turning out to be a consequential year nationally, and I think it will be locally with our elections. So this is a time for us as a legislature to be transformative in our thinking and understand that, number one, not everybody wants to run for political office or public office. So it's not as if we're going to have thousands of people suddenly signing up to run. That's not going to happen either, because not everybody wants. Some people making more money than we are, so they're not going to leave the office where they're making more money to run for our office, quite frankly. Some people, and I say this all the time, some people out there in public don't realize how hard this job is. And some people do and decide they don't want to be senators. So let's not make ourselves so special that we think everybody wants to run and be in the Senate either. That's not the case. So I just want to encourage my colleagues. It really comes down to it. It's your vote. You either vote for government employees to be able to run without having to take the onerous leave that we have in the present code, or you allow them to run without having to take leave. Thank you for your consideration, and hey, at the end of the day, whatever you decide, that's your vote, and we have to abide by it, and I surely will. Thank you very much.
Thank you so much, Senator James for that introduction. And again, I do apologize for skipping you unintentionally, just to get things rolling so that we could move forward with today's agenda. Colleagues, I will begin. We will have one round, and if we need to have another and other questions of 4 minutes on this matter. And again, for the listening and viewing audience, this measure was vetted in the Committee on Government Operations, Veteran Affairs, and Consumer Protection. But the Director for Personnel was unavailable, and she did send a letter, and we deeply appreciated that. But it's good for you to be here so we could answer the questions directly and ask the questions directly to you. The order is, first we're going to have Senator Avery Lewis, then we'll have Senator Angel Boquez Jr., then Senator Clifford Joseph, Milton Potter, Senator Novel E. Francis, Alma Francis Heiliger, myself, and then we'll round it up with the bill sponsor, Senator Maurice James. With that being said, Senator Avery Lewis, Mr. Secretary, you're recognized for your 4 minutes.
Thank you, Madam Chair, and again, good afternoon to everyone. Good afternoon to the testifiers, Director Richardson and the team, and the people of the Virgin Islands. Good afternoon. Director, I really don't have no questions for you, but I would like to make some statements on the record. The first time this bill was heard in Government Operation, Veterans Affairs, Consumer Protection, which I chaired that committee. The good director did send in a testimony at that point in time, outlining everything she repeated here today. Colleagues, at the point in time, were able to query and vet who was before us. And, we got our answers, and everybody made their decisions. But certain things stood out that day that we also understand. That this legislation recognizes a simple truth. Government employees do not surrender their rights as citizens when they enter public service. They are taxpayers. Parents, veterans, union members, educators, nurses, and first responders. They live in the same communities we represent. And they should not be forced to choose between earning a living and answering the call to serve their people through elected office. Importantly, this bill does not create a free-for-all. Division of Personnel stand ready to create policies and rules and guidelines. Am I correct, Director Richardson?
Yes.
Thank you.
And we do have the supporting rules and regs, code of conduct, and we usually, before the season, the election season, we would send out some sort of a notice to all government employees.
Thank you. And the bill draws clear, firm lines. No campaigning while on duty. No use of government resources, no misuse of authority, no violations of federal law, including the Hatch Act, no exceptions for judicial officers, law clerks, or members of the Board of Elections where conflicts are obvious. One other thing I'll put on the record is that during the conversation we had and during the vetting process, there was a consensus that some type of leave should be taken, and there's an amendment that's before legal counsel now, and one of my colleagues is bringing, that before the general election, you must take 30 days off, and you could utilize your annual leave as well. So we still make provisions that you really don't have the hardship. But if you're true campaigning and you're really out there vetting and pounding the pavement, that 30 days is well needed. And I stand before, and I stand again in favor of this bill. And my vote today will be yes, all the way. When the amendment comes, I'm going to vote in favor of that amendment as well. Thank you, Madam Chair, and that's it for me.
Thank you so much, Senator Avery Lewis. At this time, the chair will recognize Senator Angel Boquez Jr. for your 4 minutes.
Thank you, Madam Chair. Good morning, Madam Chair and colleagues. I haven't seen the amendment, so I do have some questions. In the testimony of the Director of the Division of Personnel, she mentions that they will issue policies to help agencies or employees navigate this law, but nowhere in the bill is the authority or the requirements spelled out or given to the Department of Personnel. In addition, there's a mention of the code of conduct will be used to discipline violations, but where in the bill does it assign investigative responsibility or disciplinary authority to any agency to do so? In addition, for leave and discretion equity, if 2 employees in the same office request campaign leave and one is denied while the other is approved, what protections exist to ensure any type of fairness? There's also questions around oversight. Who is responsible for monitoring or reporting any investigative violations? If an employee uses their work email to send campaign materials, which agency handles that breach? Is there any response, timeline? So these are questions that I have to ask myself. While I'm not against what the intent of the bill says, and I too have had to sustain this responsibility by having to take leave myself and understand how difficult it can be, these are some of the questions or the mechanisms that I expect to see in the bill so that there's a clear delineation of what this law's intent is trying to require. So those are my questions. Again, I have not seen the amendment to know what the amendment reflects. And hopefully I'll see it if the amendment is brought before us here today in the Committee of Rules and Judiciary, but I have not received a copy of such amendment. And we have to look at legislative gaps as well. It was stated that the existing personnel rules are sufficient, but this bill introduces, as amended, or the one that's before us, rights without any safeguards. Shouldn't the legislature consider codifying some minimum campaign conduct standards into the law? Why should we rely on a policy when we can have a clear delineation of those conduct and standards? Wouldn't it be more clearer for everyone if the bill included language that prohibits political activity to a certain extent? Again, these are the questions I ask myself. And maybe since the Director of Personnel is here, if she wants to elaborate on anything that I just mentioned. But I am seeing some gaps
30
in
seconds.
the legislation. And I just wanted to place that on the record.
Thank you for your statement, Senator. You did mention a lot of things here, and I just really want to say that the intent here was really for us to discuss having to take leave. In addition to that, we do have certain things that are in place, as mentioned, the code of conduct, the personnel rules and regs. Just everything that our leave policies are already in place, which allows for the supervisors and managers to manage. There are certain things that Division of Personnel can provide certain guidance. But again, if you are to go into these amendments, which again, we have not seen, that is where the additional discussion would then be needed if you need more information or guidance. But the intent here is for us to discuss employees having to take that leave. I'm not too much in favor of the 30 days in the sense of then it weakens the intent of this legislation. but I am confident in what we already have in place and the additional guidance that we can put out to assist supervisors, managers, agency heads in managing this moving forward.
Madam Chair, I know my time has been called, but if I may respond to the director.
Do you have a follow-up question, Senator? You may proceed.
Thank you, Madam Chair. Again, with the knowledge of not seeing the amendment, in addition to it not being clearly delineated in the bill whose responsibility a number of these things fall under, that leaves a gap, for me at least. Thank you for the time, Madam Chair.
Thank you so much, Senator Bolkes, for that line of question. Director Richardson, and that's one of the reasons why I really pushed to have you here to answer these questions, you and your team, because even though we write really great legislation here, we depend on the executive branch to implement. And we depend on you to be able to manage the work. Okay, we just like we depend on our staff, we depend on you. And of course, we don't have the previously mentioned legislation here. And we don't want to have a barrier. I'm not trying to pull up any ladder that some people that say, okay, but some of us, you have to have that level of sacrifice. Do you see with this, because I know this was some part of a contention issue relative to individuals while they are working, being able to influence voters in their workplace. And I think that was one of the issues that was surrounding the Hatch Act, even with government, federal government workers, that they could use their positions to influence voters and to influence how voters think. And I believe this was some of the reasoning that went into the legislation that was passed here in this body previously relative to Board of Elections members having to resign from being on the board. This was passed a number of years ago. I believe the author of that amendment is our current Lieutenant Governor, Tregenza Roach. And I sat as a member of the Board of Election, and we had to resign. It's reiterated in this piece of legislation, but it's already law. It's already law that if you're a Board of Election member and you're running for the Senate, you have to resign. So, and that's because you didn't want to influence individual. There was a test at one time, one board member tried to test this law, and the court ruled on that particular law. So my concern is the influence, and you're promulgating these rules and regulations to provide that supervision for persons when they're running for elected official. If they take leave, we know that they're not going to be there on site. And they have the option to take, if they take leave, they're not going to be there in the office. And that is how it currently stands. But if they're there and they're working, how are you looking at promulgating these rules that we haven't seen to really monitor individuals from taking advantage? And I just use that analogy with the Board of Elections to you, and I see it's reiterated here in this piece of legislation.
So I'm not really clear on your actual question.
Okay, my question is, what are your thoughts? What are you working on now to assure that persons are not going to, who are government workers, while they are running for office and working, is not going to use their influence to actually gain support, additional support? How do you think that can be handled? And to take advantage of whatever resources are available.
So an individual can influence a person anywhere. So again, we talked about that guidance that we put out, and we make sure that we share that and reiterate that to all government employees. I could understand when you reference the Board of Elections. That's clear. That, to me, that's a clear conflict right there. But it is something that we would have to push. Again, we put out that in the messaging, we put out the guidance, we reiterate that to the agencies, we reiterate that to the managers. And so
the question is, what consequences are you contemplating for persons who violate those regulations?
So it could come in various forms and fashions per our recommendation. Based on us finding that violation, you have the code of conduct that you can reference. It could be suspension, it could be leave without pay, it could come in various forms.
Okay, all right, thank you. The chair will now recognize Senator Clifford Joseph for your 4 minutes.
Thank you, Madam Chair, for the time. Thank you, testifiers, for being here with us today. Bill number 360134 will allow, I like fairness, and I think that this bill will allow government employees the participation that they might need, because presently what we have, it only currently exists in our law that prohibits and outdated and ensures that only individuals who are in certain financial stance actually running for elected office, and we just want to balance the playing field. This particular bill, I worked along with Attorney Maurice James on this bill, and the key factor of this was to make sure that we're balancing the playing field for individuals who work in government. And of course, individual who not going to be able, we spoke about the federal employees, and the chair just spoke about individual works or part of the Board of Election. But overall, the intent of this bill is to just make sure that we balance the playing field for individuals who might be in government that have an interest of running and can take leave from the start to the finish. I really don't have no questions other than you made it clear, Director, when you said that you're going to be reaching out to all head of agencies, and it's for them to pass the word down on individuals and behaviors to look out for. Because, of course, I don't know for sure that anything is in the bill written up for disciplinary action on individuals who violate any of the above, but disciplinary action is set forth based on if you're violating any portion of the law or any portion of your policies that's in place in each of the department, based on what you did. That's how the discipline will fall in place. I can't see that a person out here and with the era we're in, with the phones and everybody taping some, recording a next person behavior, that if you take a behavior off of a phone to somebody and you could show time that this person's out there campaigning, that they will still be to work. I'm just saying that clearly. So the individuals too who this gonna benefits should be ready to play within the space that they have. I don't see them stepping over that boundary mark. And if they do, and discipline need to be part of it, I support the discipline as well. But I am in support of Bill number 360134. And thank you for the time, Madam Chair.
Thank you, Senator.
Thank you, Senator Joseph. Senator Maurice James, you are recognized for your point of information.
Thank you, Madam Chair. I'm going to just say this. I'm really happy I went to law school. I feel good about being a lawyer this morning, really. We have a Virgin Islands Code that tells the Director of Personnel what her powers and duties are. Legislators pass statutes. We don't write regulations and rules. We give that to every single department and agency in this government. DPNR will write their own rules and regs when it comes to their jurisdiction. The police department will write their own rules and regs. Education will write their own rules and regs. Personnel, who do they have jurisdiction over? Read the code. I don't even want to read the code for the benefit of my colleagues because before you came here, you should have read the code on her jurisdiction and that she in fact can conduct investigations. That she has disciplinary authority over all the personnel in the executive. She doesn't have over the judiciary, and guess what? She doesn't have over the legislative branch because we're different branches. And we create our own rules and regs, don't we? So my question to you, I just want you, I am speaking on your behalf, but you have a young attorney sitting right next to you to educate the people of the Virgin Islands, if not my colleagues, the people of the Virgin Islands, on why it is unnecessary to put all those policies. Anyway, thank you, Madam Chair.
So if I may.
You may proceed, and I know you wanted to also, Director, respond to Senator Joseph.
Yeah, I wanted to be able to respond, but I was before Senator James mentioned, we do have legal counsel here. I did want to allow her the opportunity to comment on just what she brought up.
Thank you, Aaliyah Felix Blyden, again, legal counsel for the Division of Personnel. I wanted to provide some clarity about a few points that were made. The proposed the testimony that we submitted does not suggest that the director will actually create legislation for this particular legislation. What it is indicating is that we would provide guidance. Typically, anything that happens within the government, we are contacted and agency heads or individuals in agencies request our guidance on how to proceed with particular matters. So it would be no different. And just like the director said, prior to the cycles, we would provide certain information. It would be no different here. Generally, when we're rolling out or implementing anything new in the government, we will have an entire campaign towards guidance so that individuals understand what's happening, what's coming, how to proceed. So that was one thing I wanted to be able to clarify. And as Senator James indicated, we already have the authority to oversee employee conduct. It's part of our mandate. It's no different. This would be absolutely no different than any other violation of employee conduct and the authority that management already has to manage their personnel. So it's not unique to this legislation, and that's why it wouldn't be necessary to place within the exact language of this legislation. Right now, if there are employees who are violating the rules and regulations, any employee handbook, CBAs, etc., management has the authority to essentially manage their employees, right? If it involves progressive discipline, if it involves meetings, conducting hearings, etc., that's just what we do. I would also want to say that, at least I recommend anyway, these types of discussions really affect our entire populace who we are charged with serving, and I think these types of discussions are welcomed, and I think they need to happen earlier, sooner than later, essentially, so that we could have the conversations, we could hear from everybody that's interested what their concerns are, because the goal for all of us should be trying to make things better.
Right.
So if we get that information beforehand, and I think a lot of you guys have really good points a lot of the times, if we get that information and can have conversations prior to coming to the floor, then we can address things individually and come up with ideas collectively that can result in the betterment of our population. I just want to say maybe two more things about the potential for individuals, employees working in particular agencies, wanting to run for office and having the potential to influence votes. Right now, I could do that and not be running for office. I could be doing it to promote or support a particular candidate. I think we have to kind of think more so back to the arguments or the statements that were made about why are we here, what are we trying to accomplish, what's the objective. And as I believe Senator Lewis said, maybe somebody else said it, the objective is not to think that because we took the charge to serve our public and work in government service, right, or for the government service, that we then give up our rights to exist. And we know that that's one of our fundamental rights, being part of the political process. And it shouldn't be a hindrance just because I actually chose to serve my community, that I can't then participate in the process in that way. Or if I do so, I have to be at an extreme disadvantage, not to take away from anybody that has done it to this point and had to make the sacrifices, but because especially you have experienced it, I think instead of using, and I'm not saying that anybody here is doing that, I'm just saying that instead of using that as the baseline, I would like to see where we could come together, and if there are holes, we strengthen them, we fill them, and really try to understand at the crux what the issue is here. And it's really not creating, not maybe the intention of prohibiting individuals, but the effect is that essentially we prohibit individuals from participating in the election process. Thank you.
Okay, thank you.
Point of information.
We have a point of information from Senator Bolkes, and then point of information from Senator Francis Heiliger. Senator Bolkes, you're recognized for your point of information.
Thank you, Madam Chair. While I didn't appreciate the innuendos that were stated previously, there is what I'm clearly trying to say as I deliberate any piece of legislation that comes before us. In this specific piece of legislation, there is no clause authorizing or requiring the development of rules, policies, or promulgating of such. We have seen many pieces of legislation that have that language in it. The bill contains no enforcement provision, no agency assignment for certain things, and no reference to the Virgin Islands Administrative Code. That's all I was placing on the record. Thank you for the time, Madam Chair.
Thank you so much, Senator Bolkes, for your comments. Senator Francis Heiliger, you're recognized.
Thank you so much. The attorney from the personnel office, could you share with myself or the public, are there any current laws on the books that hinder anyone, government or private, from making the decision to run for public office? Are there any laws in existence that hinder them from making a personal decision to run for public office?
Yes.
Tell me.
Yes. The legislation that we are seeking to amend, or that we are here for today, is what we're talking about, essentially has the effect of hindering certain individuals.
That's not what I asked you. The question I asked you, are there any laws that is stopping any one of us, whether public or private, from making the decision to run for public office?
The first time you asked the question, you said what laws, or if we have any laws that hinder. So that's why I answered the way I did. But if you're saying that actually stop them, no.
Okay, so currently there are no laws that stops anyone from running for public office. Okay, thank you so much.
Except, of course,
tell me,
the Hatch Act. because that would stop you from staying employed.
Well, it doesn't stop them. They still have to make the ultimate choice if they choose to run or if they choose to stay. So the question is, technically, there's no law stopping anyone from making their own personal choice to run for public office.
Huh? Okay.
Any? None?
And I could say yes to that.
Thank you.
And I guess I just, go ahead.
This is wonderful conversation today. You're recognized, Senator James, for your point of information.
Thank you, Madam Chair. Sometimes when a question is asked, you know, it's very hard to think of everything. But while you were answering, I thought about the fact of if someone commits a crime, and that in fact, the legislature, even if a person who committed a felony wanted to run, they couldn't run. They could not. They would be disqualified from running. So there are laws. I know that what's interesting is that you can run for delegate, you could run for governor, but you can't run for the Senate. You remember that one? So this is a nice conversation, Attorney Felix. You know, what you said earlier was true. It's time for us to have these kind of conversations and answer these questions. So thank you.
Senator, this is going to be my last time recognizing you for a point of information. We have other senators here who would like to ask questions. So if we could be able to allow them to ask the point of information as well, okay? You're recognized, Senator Francis Heiliger, for your point of information that you wanted to ask.
Thank you. My colleague just shared with us in regards to how the law is structured, that based on how laws are, you could run for different positions. And if you're not a law-abiding citizen, which is actually part of the requirement to be a U.S. citizen, there are rules and regulations for your age, depending on which office you're running for. There are rules and regulations depending whether you commit a crime of moral turpitude. One has it, one doesn't have it. But at the end of the day, once those rules are met, and to even consider yourself running for office, there's nothing stopping an individual from making that personal decision. So I wouldn't put them in the same category, because you have to, even to consider wanting to run, have to meet those minimum requirements that are all listed, to include whether you're a criminal or not, or whether you're a U.S. citizen or not, or whether what your age is, depending on what you're running for. So that's how the law is set up. So I just wanted to put that on the record for clarity.
Okay, thank you so much, Senator Francis Heiliger. Senator Milton Potter, Mr. President, you're recognized for your 4 minutes.
Thank you very much, Madam Chair. Good afternoon, colleagues. A special good afternoon to folks from the Division of Personnel, Director Richardson and your team. Kind of have a little mixed emotions about this, mixed feelings about the bill. I know that I ran for office 3 times. And I know that the intensity of the campaign process during that last month is, if you are a credible candidate, I mean, it's just incredible. You're going to the candidate forum at the school, you're going to Charlotte Amalie, you're going down here, you're going to a candidate forum down there, you're on the street handing out literature. It is just something that is very intense, in my view. So I see the rationale, I see the logic in saying, I understand that there's an amendment that should be coming. I haven't seen it either. But I would be inclined to be supportive of the bill if that amendment were included as part of it. There's no way you can be on a job for that last month and do your work and still be a credible candidate for the Senate. I don't see it. That's just me. But I wanted to ask, the bill exempts judges, law clerks, Board of Election members, acknowledging the sensitivity of certain rules. But aren't there other positions that might also have this level of discretion as far as, procurement officials, licensing authorities, enforcement officers, policy directors? So I know you're shaking your head. I see the assistant commissioner shaking their heads, but I'm saying I would just like to ask you, and you have the expertise for sure, Director Richardson. I respect you. I respect your division. What are your thoughts on that? Aren't there other areas, maybe procurement officials, licensing authorities, enforcement officers, policy directors, where that whole discretionary authority as an employee may come in to the fray? Because I see the logic of excluding the judges and the law clerks and board of elections. Just wanted to hear your thoughts on that.
So I want to just touch on the comments that you made in regards to that last month. In the testimony, we did say that there is a need for the employees to ultimately assume that they will have to voluntarily take leave. That's why you have the leave. You build up your leave, and if you see the intensity of it, and you know you have to be on 3 radio shows that day, you take leave. You have
the option to do it.
The option to do it.
But you don't have to do it.
But you don't have to. But that's why it's there, and that's why we have the code of conduct to guide you so that you know, yeah, I can't punch in and go on those radio shows that day. So that's where that's where the managing of your time comes in. So I'm going to go ahead and turn it over to Assistant Director to touch on the other piece that you mentioned.
I was actually
shaking her head. Go ahead.
I was actually shaking my head because the same thing that the director saying. I was saying, you yourself know you can't be on the radio show at 9 o'clock, and you should be at work, so you should know you taking your leave, right? So that's why I was shaking my head. To your other question is, no, I think that's like overreaching, because HR professionals have reached, everybody have reached in the government. So to say, to put it to police or to procurement, everybody would fit into that category, Senator Potter.
So you think that the exemption for the law clerks, the Board of Elections, and the judges, that is it? That's a finite group of people who you think would have an influence?
I don't think the judiciary have an influence. I think the judiciary is the one who is saying that their people shouldn't be involved in it. For the Board of Elections, is that if you work for the Board of Elections, how could you then run? You need to resign, because then you have a clear influence, because I work in that office. So then, therefore, I could be looking at individuals' registration, know how they're registering, contacting them and saying, I need your vote, I want your vote. But with the judiciary, their individuals should not run or shouldn't be engaged in politics, because they make certain decisions and individuals have come before them.
They see a conflict.
And
so
they
they
see a
choose to
conflict.
exclude their folks.
If I could just add, the judiciary and its specific officers in the judiciary is holistically different. At least that's my perspective. And not because just they're a separate branch, but because they actually adjudicate cases that may come before them. So it's inappropriate. It's the same reason why you rarely see them before this body testifying. It's the same sentiment why they wouldn't, at least those specific officials or officers of the judiciary would be exempted. And the Board of Election members, same thing. They have direct influence over the election process, which is holistically different than, let's say, me as the attorney of the Division of Personnel, or our janitor, or the different individuals that might work in a particular agency.
Question. Thank you for your response. I just thought about it when you were doing your presentation. If I am a supervisor, if a scenario on a job, if a supervisor who is running for office, supervising a subordinate employee, Are there any thoughts about that type of scenario and the
Time.
potential for coercion? Basically, I'm a supervisor, it's a position of power, I'm running for office. Is that something that would be concerning to you?
Senator Potter, I would say no, because some employees don't care for the supervisor, so it wouldn't care to them one way or the other, whether you're running or not. And
Some do,
the
some
truth.
don't.
Some do, some
And
don't.
some may
but
feel-
even if they're out of the office on leave, if I like my supervisor, I'm still going to vote for my supervisor, whether I'm in or out. It doesn't matter to me. So I don't think that that's a argument.
You
in
don't
my
think that
case.
situation of power, the power
No.
dynamics would enter into play
No.
with a supervisor who is running for office and a subordinate?
I don't think
differ,
so.
I differ with that. I differ with
Okay.
that. But, Madam Chair, thank you very much for your generosity. I support this bill with the amendment, if it comes, to require employees to take leave at least 30 days prior to Election Day. Thank you very much.
Thank you so much, Senate President. I do have a question before I recognize Senator Novell E. Francis Jr. And before I ask my question, I also want to recognize non-committee member Senator Hubert Frederick, who has joined us in the conference room in St. Croix. Now, my question is this. I know you're saying you will provide guidance. To me, that leaves it too much up in the air. You know, I like things to be uniform because sometimes, you know, it depends on relationships, how people react to certain things and how they, you know, implement and they discipline. It depends on relationships. Everything is relationships, Garrett. Has there been any consideration, and I'm always asking this consideration because I understand your role, because we did something similar when we allowed retirees to come back. We had legislation where we gave a time frame for those rules to be promulgated before and how it should work by the Division of Personnel. Do you think it would be beneficial with this bill to have certain guidelines, those guidelines, so it's uniformed prior to this bill being implemented? Say we give you as an amendment, say 30 days to come up with those guidelines so that the supervisors and everyone would know what those rules, regulation, and that guidance would be, so that they're not shooting blindly. They have something that is written outside of it, what the supervisor would be looking for, what the level of disciplinary action that can be taking place, all of those things. Because I know that the division, the personnel handbook hasn't been updated for how long?
So you are correct in a sense that the handbook has not been updated in a while.
How long do you remember? It's been decades, right?
The 80s, I think.
How-
In the 80s,
So
maybe.
it's antiquated.
So it is antiquated. However, we've made a few changes here and there. We've also made some updates to the rules and regs. We've updated the employee code of conduct that hadn't been updated since 1962. And I do think it's a very, very strong document that we could use as a very strong base with this particular bill. You know, I can't comment on the type of guidance that you're referencing unless, you know, we do in fact have that amendment that you are talking about to see what those details would look like. You know, we have in fact met with the bill sponsor in the 35th legislature and had some very extensive meetings and provided suggestions. even with this reiteration of the bill, we'd had time that we met with the bill sponsor and we made suggestions to strengthen this bill. So that's why we're here. You know, if this is to be amended, I do think that it would require the additional discussions to ensure that we are making the right suggestions and amendments. As it pertains to rules and regs to support an amendment, that is something that the division can do, but I do think the basis of what we have already in place is strong enough. But depending on what that amendment looks like, we could have those discussions to then talk about if additional rules and regs are in fact needed.
Yeah, because you mentioned you will be giving guidance to supervisors and the like. And so for me, I like words. I like it to be laid out so that everyone is actually using the same sheet of paper. That's how I could tell you with this bill when it mentions the Board of Elections members may not be a candidate if they're running for any public office outside of the Board of Elections, that they have to resign their position, because that, I know, I tested that. And the law was very clear, and of course that was tested in the judicial branch. I'm going to...
So I do need to add to what you said, because you made a reference to some of the other rules and regs that we did as it pertains to the retirees returning to work. And the Division of Personnel can in fact put something in place. The guidance that we're talking about could come in the form of a flyer. It could come in the form of an email to all government employees. It could come to something on our website. It could come to, additional postings on social media. We have different ways of reaching all of our employees. We do monthly 2-hour trainings with our HR professionals. So if it means having to pull them in and educate them on what the requirements are and how they can utilize the code of conduct, what's required, what should they look for, look at funding and everything like that. We can do that.
Yes.
That's not an issue.
And that's what I was getting at with this. If we could make sure that is part of it. I don't want it to be left up to the supervisor and they are not unarmed. I'm not saying that is going to be the case with you here, because I know you're very diligent, but you don't know what may happen in the future 2-3 months. But if it's written in law that you should have this type of rules and regulations in place, guidance to provide persons who are now in this arena, and the supervisors who are left there, they know what to look for. They don't have to come to you all the time. That's my concern. Senator Novell E. Francis Jr., you're recognized for your 4 minutes.
Thank you very much, Madam Chair, and I want to first of all commend the bill sponsor for moving this legislation forward. I continue to be constant and consistent in my support for this piece of legislation moving forward in respect to leveling the playing field by which we could allow for individual government employees to be able to run for office. I truly believe that there's and it already exists in terms of guidelines and framework by certain agencies in respect to providing the policies and rules and regulations in regards to the do's and don'ts, and as well as the code of ethical conduct that would allow for us to be able to hold individuals accountable. The issue, again, is enforcement. You could have all the policies, all the rules. If we're not enforcing those, then we're all doing this for naught. So there's nothing that precludes any senator from moving an amendment to say that, within the 30 days, 45 days, 90 days, or whatever there need to be some policy put in place, so that they can be consistent across the board. In respect to whether or not the current laws stop or hinder individual from being able to run for office, I would respond with a resounding no. However, it is conditional. It presents a hardship in certain individuals to be able to run for office, hence the legislation to address that particular issue. I also support the notion of the 30-day out, that some type of leave should be taken again to allow for that individual then to focus on the mission at hand, which is to be elected, so that they could have sufficient time to be able to do that. Your vote is a sacred vote, right? So whether or not there's any influence or equally discouragement by any individual from, again, impacting an election of a particular individual, is there. There is no perfect bill, and of course, you know, as we move along, it's a work in progress, and I suggest that in any suggested amendment should be exercised so that we can strengthen this piece of legislation, but it's time. It is time for us to level the playing field and allow for government employees without having to endure the hardship that some of you have already mentioned that you have to endure while running for office as a people's representative. We have to level the playing field moving forward. I wanted to ask you real quickly, Director Richardson, do you have any data to support the amount of individuals that may have requested some form of leave of absence in the past, maybe the past 2 elections or so? Do you have any data to support that, what that number looked like?
I wouldn't have that data. Usually those requests for leave would go to the agency head or to their direct supervisor.
Okay, so that's not something that will come to the Division of Personnel for that extended leave?
No.
Okay. Again, I don't have any other questions. I think the time is right for us to be able to do the right thing, which is to level the playing field and open the door to allow for individuals to seek removing that hardship that have been mentioned by individuals time and time again, so that they could be able to run. And I also embrace, again, the notion of the 30-day out for some type of leave, you know, so that we could take away any issues or concerns and allow for other individuals to be able to do this on a full-time basis so that they can make their case. Thank you very much, Madam Chair, for the time and opportunity.
Senator Maurice James, you are recognized for your point of information.
Okay, I have a great point of information. This is my buddy here. He and I born on November 22nd, so he can take whatever I send in his way. This is, so let's say that my colleague here, Senator Potter, decides to run for governor of the Virgin Islands, and his best buddy here is not running for anything, but he asked me to be his territorial campaign manager. But I'm still working as a government employee. Should I now have to take leave in the last month that I have to support you? Because the campaign activity is going to increase so much. Should I have, is that one of the people you were talking about that would have to now take leave, even though I am not running for office, but I'm here supporting my colleague? I mean, there's a lot of work for me to do in the last month. Right? You understand what I'm going at, right? We're going to have to start picking and... Okay, that's the question.
Point of information, Senate President Potter.
Thank you very much, Madam Chair. Just to respond to my good friend and my birthday partner here on the right, what I'm saying is once you are running, if you are a declared candidate for office, then and only then should you be mandated to take leave for that 30-day period. So that's my thoughts on that.
And I appreciate that. Now, the proponent had a question, and do you need her to repeat it, or you are comfortable in answering it?
They have to do campaign workups too.
So, yes, the individual who is running would then in fact take leave once, you know, within those 30 days. Hypothetical campaign manager, ethically, should take leave. And I say that in the sense of my previous example. If you have to be on 3 islands in one day, traveling back and forth, you should take that time off.
If I could just add, while I think that was an excellent question to drive home the point, we note that, I hope at least it highlighted that to then get that granular to say we would have to go in to inspect or designate the level of involvement of each government employee to then mandate whether they should take leave or be required to take leave would be almost impossible. And I think what I got from the well-respected Senator Potter is he himself didn't believe that that should be required, correct?
That the non-senator?
Correct, that only the one running should be required to not be working. So I'm just saying, if essentially what's good for the goose is good for the gander, all of the arguments as to why the individual not running shouldn't have to take leave would apply, or should apply if that's what we're saying. But we're not going that, I would assume we wouldn't suggest going that granular.
No, because, you know, for me, I think when you are a supervisor, right, you have employees who go above and beyond. And there are certain compensations you make for that employee. I mean, you have employees who work, they are scheduled to work 8 hours a day, and some of them put in the 14. And you say to yourself, okay, you put in the 14, I need to go do X, Y, and Z. I'm going to give you the time off, right, without penalizing you, because guess what? When crunch time comes, I could depend on you. So the supervisor have that discretion, okay, to make those judgment calls. And that's why I don't necessarily support it for a non-public official office for somebody, if they're a campaign manager and anything, because as long as the work is being done, and I'm very basic, very basic, just get this work done and let's move forward. But just don't take advantage of the system and use your influence to sway voters. Even though you're going to use it, try not to use it. Senator Alma Francis Heiliger, you're recognized for your 4 minutes.
Thank you. In regards to that scenario, I also do not support a secondary person would have to take time off, because how you choose to run your campaign has to do with your time management. And you necessarily don't have to go on a plane with the candidate. You could send other individuals. There are a lot of retired people that work on campaigns. There's a lot of people that have that kind of leisure time to work with that particular candidate. So I see that as secondary. How many employees total work for the government of the Virgin Islands?
Total, include all branches,
yes,
about close to 10,000.
About 10,000.
Yeah.
That's I had almost 10.6 or something like that. The reason why I asked that question is we make a lot of argument about creating barriers and hindering people, when in all honesty, the hindrance really isn't there, because it's still ultimately a personal choice once you meet the qualifications. And I get a little bit concerned as a representative, because we seem to want to put this impression out to the public that the senators are hindering things when we represent everyone in the territory. And we're not mentioning the fact that while there might be 10,000 government employees, there are 25,000 private sector employees too that don't have this same opportunity. It is still ultimately boiled down to them making a personal choice. And a lot of those businesses will either ask them to resign or either go on leave without pay. And that's the reality of the situation. So while we make it seem as if though we're trying to block people, that's not the thought process I'm having. And I understand your statement earlier when you shared that you don't feel that we should do the 30 days. You know, I can't make decisions on your feelings. I can make decisions based on data and even sometimes facts or experiences. And I am the author of that piece of legislation for the 30 days. You were not here during the last hearing, and the majority of us said that, you know, to cut it down from 6 months, because that's ultimately the time off that the individual would take, it would basically be cut down to 5 months, and that 30 days because of how vigorous those last campaign days are. And let's be serious. If you are really, really about campaigning and becoming a representative of the people, you have to put in the time. And I was one of those initially that thought, hey, I could willy-nilly run for office and still work full-time, and it can't be done, really. Because when you're working day to day, your full 8 hours from 8 to 5, let's be honest. I'm thinking about campaigning. I'm worried about, did I turn in enough pamphlets? So I understand what we're trying to do. But I don't want the message to go out to the public like we're trying to gatekeep. That is not the situation. And the other thing I want to state earlier, I understand my colleague speaks about we could have a part-time legislature. I understand that statement, but you also have to recognize how this Virgin Islands is set up is not like any of the 51 states. Because when a part-time legislature only comes in to deal with laws, you have to be mindful that state might have an alderman, that state might have a councilman, that state might have a mayor, that state might have so many other levels of representation for the people that even if the legislature is part-time, it doesn't matter. That is not the situation in the Virgin Islands. So I don't want us to start mixing apples with oranges.
Time.
Madam Chair, could I get to my...
Time is running.
Okay.
You may proceed, Senator.
Thank you. My one question I want to ask, the amendment that I'm bringing forward, and I got an amendment back. The problem is how it was written. It just simply stated that they would have to take 30 days off. And I didn't think that was sufficient for what I wanted to represent. And after speaking to several of my colleagues, what we actually wanted it to say was 30 days off with pay, that they have to take the time off. The draft that I saw spoke to they shall be granted. And I'm like, so what if they don't ask? What is there to grant? You have to state they must take off the 30 days and they could utilize their leave with pay. But unfortunately, you know, for the past 7 hours, we've been trying to get back a copy of this. So hopefully if legal counsel gives it to us before this meeting is over, we'll be able to circulate it and vote accordingly once we could get that part in. So it's not that anyone here has not made compromises, because a lot of us have said, you know what, we can make the compromise to go down from the 6 months down to the 5 with the 30 days inclusive. But I just don't want a particular message to go out to the public that, you know, I saw it as a hardship. I saw it as a hardship when I ran, but it was also a personal choice because I believed in myself to represent the people well. So I did what I had to do. So if we're gonna be making it a little bit easier for others, I don't have a problem with that. But just don't make it seem like we're trying to block everything when we're just trying to use our experience and the facts that are before us. Thank you so much, Madam Chair.
Hello, yes. Thank you so much, Senator Francis Heiliger. Did you have a personnel? Do you want to respond?
So I appreciate those comments, and and that's why I mentioned that having these type of healthy dialogue helps to strengthen the bills. And I do think, you know, when I want to just talk a little bit about some of the hardships, because, you know, when you go and you take, some people end up use or build up their leave and they take that, so they're getting paid. But then when that runs out, you end up now having to pay your employee side of GRS. You have to pay your insurance premiums, you know, and other expenses that you may have. And so that's really where the hardship comes in. And especially for the insurance premiums, that's where, you know, if you fall off of that, Cigna can then bill you in full if you're not paying for that, paying your employee side. So that's really where a lot of the hardship comes in. So, and that 30 days, and it's important that you say off with pay and clarify that too as well. But also to take into consideration the leave and stuff like that that's being accrued as well into consideration as well.
Okay, thank you so much, Director, for that comment. At this time, the chair will recognize Senator Hubert Frederick. Senator Frederick, you are recognized for your 4 minutes.
Thank you very much, Madam Chair. A pleasant good afternoon, colleagues, listening and viewing audience. My office of Senator Frederick, and Central staff, employees, Happy New Year all. It's good to see everyone back to work, happy and safe. My perception about our conversation on this bill is still developing, because I come from a different background. I am a pure private sector background, and this bill specifically speaks to government employees, as if government employees don't have an inherent advantage over the political process as it is. If I was a private sector employee, this bill definitely would give my opponent an advantage, because I can't take off time if I work for a private company. They won't pay me leave, but my opponent now will have an inherent advantage because they're getting compensated while they're trying to run for the same seat that I'm trying to get. And the reason why I'm bringing this up is because, as my colleague previously said, we've got 25,000 public sector employees, 10,000 government employees. That's a 40% difference in terms of private, public-private relationship right there. 40% of our total employment is government employees, and we're bringing up a measure that will give them an advantage over the other 25,000 people. I don't know if that's fair and equitable. Everyone should have the opportunity to run for public office if they so desire. If we incentivize one side more than the other, that's a disadvantage to the other side. And that's not what we want. Everyone pays taxes. Everyone wants a fair government. Everyone wants to have an opportunity, if they want to serve, to serve. But if we keep putting most of the benefits on just government employees, then it becomes unfair. We just had our Crucian Christmas Festival, and government employees had a lot of time off, paid time off, and that's fine. How many private sector employees could say the same? So I'm saying this to remind us that sometimes we have to step back and see if we're not tilting the barrel too much and giving, one side more than the other, because we're all one community. And although I'm one of the few senators that's fully private sector, I mean, I love my colleagues who are fully government. They've spent day one working for the government to retirement and back. And that's fine. We need that experience. But we also need experience from the other side too. It's a community we're dealing with. We all need input from all sides. And so my 2 cents is, I haven't seen the amendment. I'm looking forward to seeing the amendment to make sure no matter how you turn a good public policy, it should look fair on both sides. And so I'm asking that we consider not making it disadvantageous for non-government employees as well. When we make our consideration, think about that. But I don't have any problems. I'm not against government employees getting paid. I just don't want them to have an advantage over non-government employees. It would be unfair, and I principally have issues with that. Thank you very much for the time, Madam Chair.
Thank you so much, Senator Frederick, for those comments. Senator Maurice James, you have a point of information.
Yes. Thank you, Madam Chair. Does the government of the Virgin Islands provide health insurance for private sector employees? Do you?
No, we do not.
Thank you, Madam Chair.
Thank you so much. I think what my good colleague from St. Croix was trying to allude to is, that everybody, and one another colleague mentioned, everybody has a choice when you're going to go after anything. You have a choice of where you're going to live. You have a choice of what type of job you want to apply to. And so sometimes there are a little bit of advantages for persons, but I look at it as that if you really serious and you're hungry for something, you are going to do it. You're going to put your all into it. That's how I look at it. So whether you're in the private sector or the public sector, if you are truly want or feel that, and have that sense and that purpose, that's what it is, the purpose, and you are purposely driven to serve the people of the Virgin Islands in whatever capacity, I think you are able to do that. Our previous speaker and the nominee for judgeship of the Superior Court, he spent 40 years in the private sector. 40 years, a lot of years in the private sector as an attorney. He's been working as an attorney for many years, and he's finally going to look at and be a judge for the Superior Court after being an attorney in the private sector in various capacities and being a consultant. I want to take up my time, and Madam Clerk, just put 4 minutes on the clock for me. I did think it would be better, because I love policies and procedures that are standardized. I like standardized, because then it doesn't leave people with a question mark whether how things are going to be managed, what type of discipline, and all and the like. And I love that you have those guidance and being able to educate supervisors so people know from the front end what are the expectations, what can happen, or what will happen because of their actions. I remember a freshman senator came in and they weren't aware of certain processes, and you had to, as a vet, as a more seasoned senator, you had to let them know, and they would say all the time, I wasn't aware of that. Nobody told me this, because it's not written. And so when you have those standard procedures and standards, rules and regulation, it definitely helps to clarify the gray area. And that's one of the questions I was asking you, Director, about the consideration about putting that in place, and also with your education campaign, because we do want to see more people in the midst. My question is relative to how you would look at if an amendment was brought to do that, to do specific promulgation of rules and regulations. How much time you think you would need and guidance to provide that guidance to your managers and other teammates?
So in order to provide the guidance that would be needed for additional rules and regs, it would take time to develop. I would say, as far as the guidance to them would be anywhere from about 30 days to roll that out to them. However, to write and do those rules and regs, that process to actually have them promulgated is what takes a lot of time. It does leave Division of Personnel, it has to go to Justice, it has to go to Office of the Governor, you sometimes have to put it out for comment. So, even going through that process, that takes some time. But once that is done, we can then do the education piece. But that
Okay.
promulgation is what takes time.
Okay, so how long do you think? 60 days?
No, that takes longer than.
When you say how long do you think, you mean the process to promulgate? That could take 6 months.
Yeah.
That
Okay,
could
so
take
we're
up to a
going,
year.
I understand, but we're going to give you some timelines. So hopefully you can work within those timelines to make it happen.
Well, when
Okay?
you say that, just to clarify, that is outside of our control.
I know,
Okay.
I know,
Okay.
I know, and we will put in those guidelines. Now, and of course, this is a deliberative body. My colleagues could say yes, they could say no with the amendment that I'm proposing, and it could fly. But I love timelines. I like giving people
30 seconds?
Time to do and give us the guidance with standard procedures. And that's one of the reasons when this bill was heard in the Committee of Jurisdiction, I needed to have you here. I needed to have the Division of Personnel here to have this really great conversation. Now, this is just philosophical. There is a philosophical situation about adherent of government operation that thank you, we have a right, persons who pay their taxes have a right to receive services. Do you see that this could in any way affect the services that the government provides? I don't want us, because we are already having issues with filling vacancies. That's one of the things. We have issues filling a lot of vacancies. We don't have the amount of workforce that we had before. Let's be real. We don't have it. That's why we had to open up some of the windows to bring back the retirees. Do you see in any way that we can assure that those positions, persons can still operate? This bill will still allow the government to operate, because we will be offering them an opportunity to continue to work as well as, take leave after a certain time.
Thank you, Senator. I think this goes back to what Senator James said in her opening. We don't want the situation where we prohibit government operations or we hinder government operations. So again, we haven't seen the amendment. However, based on what was stated on the floor, it sounds like we are all open, or most of us are open to a situation where we can afford government employees specifically the opportunity to continue working to benefit them, as well as to benefit the people of the Virgin Islands who we serve, and therefore government operations will continue. If we're just talking about specifically the amendment and the 30 days and whether that would allow for the continuity, I would believe that would be yes, it would allow that, right? Right now, people can take leave, they take leave, right? And we have to continue. And as the senator said initially, we don't envision that this then would open a floodgate, so then you'd have a mass of individuals exercising this opportunity, right? So then you'd be in a position where really you're at a loss. However, we note that there are a lot of agencies, and within a lot of agencies, there's critical staff shortages. So individuals who, it may just be one person leaving, and that causes a bottleneck. I think, again, it really is gonna take, it's difficult to say in this moment. We're gonna have to have the discussion to really develop, even with the rules and regs, when you ask how long, it's gonna take some communication, some discourse to really see what's the best way to apply or implement what we're talking about.
And that's my concern regarding the implementation, because I keep on the back of my mind, that government must function. Everyone in the community is dependent on the government, and everyone who is dependent on the private sector to do their work. Because in the private sector, you could go to a different competitor. That's part of the type of system that we have, but we have only one government. There's no competing entity. And so those are the questions. That was my concern. I had mentioned it to the bill sponsor, this philosophical adherent government operations that it must function. And for me, as being a representative and knowing that people have a lot of concerns, we as representatives of the people, we don't get calls out in the night. The legislature was on recess, but that doesn't mean the senators were on recess, though. You're doing business. And so it is that concern that I have regarding that. This time, I will recognize the bill's sponsor, Senator Maurice James.
Thank you.
Senator James, you're recognized.
Thank you, Madam Chair. First of all, I want to let the young people out there know that the VI Slice program has reopened. And I'm actually going to use that as an analogy. I have a choice to buy a house. I can. I may want to buy a house. But the cost of buying a house may be out of reach. Similarly, I may want to be a senator, but the financial hardship of taking leave, as was mentioned, the insurance premiums, all the other things that I was happy when we had that meeting, I wasn't even aware of. It's affected. I may want to do that, but the cost of a campaign, which includes the cost of my having to use my annual leave now, is out of reach really for me, especially if I am a young person who want to run. And I started my opening by saying that as a private sector employee, I was not aware of the financial hardship until I was told that by a colleague. And I suddenly thought, wow, they really have to go out of the way to. I was fortunate because I was a solo practitioner, private, so I give myself leave, right? But I continued to work all the way through. I never stopped working. I represented my clients. So when I say I give myself leave, okay, to go to a forum, right? But I still represented my clients all the way through because I'm legally obligated to do that. I don't think any government employee is any different from me as a private sector attorney who is legally obligated to provide the government of the Virgin Islands with 40 hours per week if they're there at their job. And as the director said, if they want to go to a forum, ethically, and I'm so happy you used that word when you said, as if I were the territorial campaign manager, I should take leave. That's just the right thing to do. But we can't ignore the fact that it happens throughout government, that people in fact do not take leave. We seem to be focused simply on the people who choose to run or want to run, as opposed to all government employees. So I want to point out that when it comes, I'm glad you said that for you to do the regulations, the rules and regs and policy and guidelines, young attorney Felix knows we don't reinvent the wheel as attorneys. You could go to the federal government and you'll see political activity, do's and don'ts. I mean, you can go to practically any state and you'll see that. I was wondering if even within the legislature, for our employees in the legislature, if we even have political activity, do's and don'ts for our employees within the legislature. The judicial branch clearly has theirs, but do we have? No one has answered me yet, so I'm going to have to go and search to see if we do, but I'm not aware of it. So we put in a lot on the executive branch because clearly you have the most employees, but you also have, based on the code and what you've said here in your handbook, you already have the structure in place to discipline your employees, to tell employees not to go I mean, for anything to take off, unless the governor grants administrative leave, I'm sure there were a number of employees who took annual leave during the Christmas festivities because that's the right thing to do. So I don't really have any questions because we're on the same page. And I'm happy that I met with you, and I'm happy that you made me aware of all the other difficulties that I was not even aware of when it came to how an employee can suffer when they choose. I know we're talking about choice, but with that choice, an attorney friend of mine sent a text to me saying, if we look at the poll tax in the South, look at the poll tax. We could say to blacks, you can vote, but if we couldn't afford to pay that poll tax, they couldn't vote. They couldn't vote. So we're almost, I notice you're smiling because you understand what I'm saying? I mean, you said it? Okay, yeah. I'm like, are we not, we're supposed to be progressive, and in this time and 2026, really a black and brown community and what's happening out there in the world, we need to be more conscious and we need to be more kind to our employees. And so at the end of the day, I only have one vote. I don't vote in the Rules Committee, but I'm asking my colleagues to vote for my bill. I'm asking you not to include guidelines and regs and rules when in fact the personnel already has that power in the code, but they already have the power to create rules and regs for anything. Sexual harassment, you already have to deal with that, right? Family leave, you already, you deal with almost everything that has to do with employees. I'm sure you probably have, I don't know, I'm only throwing out these things, but you already have policies in place, and that's what I want to point out to my colleagues. Let's not overreach into the executive branch, because we now have to have our own rules with respect to political activity. So I will thank the Madam Chair for having this hearing today, and I hope I've convinced my colleagues that we need to move forward and give our employees the opportunity. By the way, one thing before, just one thing. At the end of the day, we're giving our employees the right to run without having to take leave, and I know my colleague has an amendment. But at the end of the day, the people are going to vote. You can't say, well, they have an advantage over the private sector. I'm hoping that the people of the Virgin Islands, more this year than any year, vote for people who have character, commitment, courage. Those are the things, not if they have leave, but if they have the qualifications, the credentials to take this government forward, whether they have leave or not. Okay, that's what we vote for people. And by the way, you're going to hear me talk about that all year, because guess what? I do have the freedom. Thank you very much. I yield back to you.
Senator Francis Heiliger. I say I wasn't going to allow you any more pointer information,
Well, I appreciate it, Madam Chair.
Oh, okay. Go forward, Senator, because this is a very important discussion, and we want to try to get it as right as possible, okay?
I just want to put something on the record while we're having this discussion, just to show how certain laws, if you don't write certain things down, how it could go. Earlier when you stated, I think it was the attorney from personnel spoke about the fact that they're not going to necessarily, they're going to be guiding how these potential policies are. They're going to give guidance. And that rang an alarm with me, because if you have 10 different agencies call you, you give guidance, each agency could now create their own individual policy around the same thing. So I needed a little bit of clarity on that. And I'm going to tell you why. There was a special election several years ago, and I participated in it. And because our law didn't have any set guidelines as it relates to special elections, when we all had to take leave of absence, or we thought we did, some of the people that were running got to stay on the job and got paid, while the legislature told me I had to go on leave. And I thought that was so unfair because everybody interpreted the law how they choose fit. And I didn't think that was a fair situation because now you have two government employees running, one got to stay on the job and one had to leave in the same identical special election. So I'm just showing you that these type of things do happen if stuff are not documented or either codified or there's a set of rules that would apply to everybody. So thank you so much, Madam Chair.
Thank you so much, Senator Francis Heiliger. Attorney, you wanted to comment on that?
Yes, thank you, Senator. So the testimony, the intent of the testimony was not to say that we will not promulgate rules and regs. I just wanted to clarify that that isn't what it was saying. We were just speaking generally about what we typically do, which is provide guidance to all government agencies. And so when I say, or when the testimony says guidance, what we mean is that we direct them to the rules that already exist. Even though we say that, based on the discussions we've had, and at least my position is, we are never closed-minded to amendments or, again, things that strengthen. So when you propose including language that essentially puts pen to paper, we're not opposed to it. I think the senator is correct, James, as well as we are saying this isn't some new type of employee conduct or behavior that needs management. It is no different than any other employee conduct or behavior that needs management, and we already have rules for that. So what I would advise the director to recommend to any agency is following what is in place in terms of management of personnel, progressive discipline for anything else that would be a violation of our policies or our rules and regs. However, as I say all of that, we are not opposed in this particular situation because we understand the magnitude of this situation, and I wouldn't want that this is a hiccup that doesn't get the measure passed. I would recommend that we can, and I would suggest that we do formalize what the guidance in particular is, if that is needed to move forward.
If I could add, Director, in the past and in recent time, the guidance have been in writing. And when it's in writing, it also states that progressive disciplinary action could take place if you don't adhere to the policies, which we have the executive order on conduct. And many times that have been adhered to, and we have had no issues, none whatsoever. So I just want to put that out there.
Okay, thank you so much. Colleagues, Senator Hubert Frederick, you had a point of information?
Yes, Madam Chair. Thank
Okay.
you very much. I just have one question for the Director of Personnel, Director Richardson. Can you tell me what is the estimated cost to taxpayers for this bill, given that there's an enforcement cost, a policy development cost, indirect costs, and the costs that we would incur as a government by losing the services for these employees while they're doing this? What is that cost? Did anyone estimate what it might be to the government?
I'm Senator, I'm not exactly sure the direction, but I information.
Every policy, public policy, has a cost. This one definitely has a cost. And given the fact that we're so challenged financially, it's important that we know what this would cost us as a government.
You would have no
So
idea as to the
someone
number
should
of
be
individuals that
able
would be
to give
running.
us,
So
someone should be able to give us that information.
you wouldn't know, Senator, off the top right now how many people would run. So you can't really give a cost as to what that would look like.
Thank you very much for the time, Madam Chair.
Thank you so much, Senator Frederick. And, you know, everything has a cost, okay? But whether or not we could assess those costs, and if what we would know, remember this legislation is going to be an experiment. And with that experiment, and most legislations, that's what it is, you know, it's an experiment to see how it's going to function and how it's going to be implemented and what costs. So this is an experiment. It was experimented upon before, and then it was rolled back. I remember Act number 6634, they was there in that experiment, as well as in Act 6488. Those were experiments. So these are just what they are with bills and legislations to see how we are going to be able to implement and how it works out. Senator Maurice James, point of information, and this will be the last point of information, then we'll take a little break, okay?
Yeah, I don't have a problem with that. Thank you, Madam Chair. Because you said everything has a cost, and I'm so glad you said that. Yeah. Because when you force government employees to take annual leave and be away from their duties, that's the cost to the people of the Virgin Islands. The loss of productivity at the workplace. That's the cost. That's the cost you need to measure. Every single time an employee has to take leave and not be at the job. That's the cost that I am trying to avoid. By having them on the job, the government is paying them what they regularly would pay them. There is no difference. When we require them, as my colleague is saying, to take the 30 days annual leave, again, that's the cost to the employee in terms of money. The cost to the government is the absence of productivity for 30 days. So when we talk about costs, let's be clear about what we're talking about. That's it. I don't want people out there to think that, and then when you said that, Madam Chair, and you're proposing the guidance that or the guidelines that the department, division of personnel, that's their job to promulgate policies and guidelines. That's their job. They're paid to do that already. So what additional cost is, that's what they should do. We should all have policies in place for everything in government. So the cost is greater with the existing legislation that we have right now. But thank you, Madam Chair, because I think it was very important for you to have the Director of Personnel here. I was myself I wanted it done last year, but I do appreciate the fact that we had this today because it's clearer for me. And I do want to say this, that we've had a very good discourse today, I think, whether we agreed or disagreed. And I want to thank my colleagues for offering their opinions. And as the young attorney Felix Blyden knows, attorneys we could cuss one another out, but when we walk out the courtroom, we're good. Thank you.
Thank you so much, Senator. We're going to take a little break. I just want to, before we take a little recess, that I just want to state that, you know, this is a very, very great opportunity for us to have this conversation. And there always are going to be costs. And for me, I like to see things in black and white, especially when we are advising people and it's not up in the air, so that everybody is on the same playing field. That's just how I am, because I know that typically there are times where it's good for the goose and that is not good for the gander. And one of my colleagues outlined one of the instances that happened. The committee stands in recess for 5 minutes.
Okay.
And we are back on the record. Thank you. Do I hear a motion? Senator Milton Potter, you're recognized for your motion.
Thank you very much, Madam Chair. Madam Chair, I vote to move the vote on bill number 36-0134 to the end of the agenda. I so move.
Bill, there's a motion to move bill number 36-0134 to the end of block 3 of today's agenda. It's been properly moved by Senator Potter and seconded by Senator Francis Heiliger. And hearing no objection, so ordered. At this time, I will ask the Director of Personnel to kindly place your 30 seconds wrap up on today's agenda, on today's record, I'm sorry, today's record. Kindly proceed to wrap up, Director. Media, kindly recognize the mic of the Director of Personnel. Try again, Director.
Good afternoon.
Good.
So the Division of Personnel would like to thank you for the opportunity to provide commentary on Bill number 36-0134, which allows for government employee to run for political office. The Division of Personnel has worked closely with the bill sponsor, and the work that we have done has pretty much helped to modernize an outdated framework that has usually, in some cases, discouraged and prevented employees from actually running for public service. Public service is not always easy, but it is something that I think that we should look at closely. And when we encourage people to run for office, to return home, when we think about succession planning, it is something that we should take into consideration. And I do ask the viewing and listening audience to pay attention to the progress of this bill, as I do feel that it will benefit the future of the legislature of the Virgin Islands. And I thank you for our opportunity today.
And thank you, Director, for your guidance, your candidness throughout this process. And I want to also thank you for being available today. We definitely appreciate you and your team being here to answer the questions that we had relative to this bill. This is part of the vetting process, and as the chairperson for this committee, is my responsibility to assure that the bills are properly vetted before they proceed on to a legislative session, to the best of my ability. You are, and your colleagues are released from your testimony before the Committee on Rules and Judiciary. Colleagues, we didn't get any lunch, and our central staff hasn't gotten any lunch either. We've been working. The committee is going to stand in recess for 30 minutes. And we are back in the record. Madam Clerk, kindly proceed to reading Block 3, our final block for today's agenda, into the record.
Bill number 36-0089, an act approving the lease agreement between the Government of the Virgin Islands and PEO Productions, LLC, DBA, WSTA Radio for parcel number 121 Submarine Base, number 6 Southside Quarter, St. Thomas, Virgin Islands, parcel number 167 Subbase, number 6 Southside Quarter, St. Thomas, and parcel number 171 Subbase, number 6 Southside Quarter, St. Thomas. Proposed by Senator Milton E. Potter by request of the Governor. Bill number 36-0092, an act approving the lease agreement between the Government of the Virgin Islands and the St. John Taxi Service Corporation for parcel number D-2 Estate Cruise Bay Town, Cruise Bay Quarter, St. John, Virgin Islands. Proposed by Senator Angel L. Bocas Jr. and Marvin A. Blyden by request of the Governor. Bill number 36-0030, an act amending Title 24 Virgin Islands Code, Chapter 1, Section 4, increasing the minimum wage, proposed by Senator Franklin D. Johnson. Bill number 36-0208, a resolution recognizing United States Senator Mike Crapo for his instrumental role in securing the historic increase in the rum cover-over tax reimbursement for the Virgin Islands, proposed by Senator Avery L. Lewis. Bill number 36-0105, an act amending Title 7 Virgin Islands Code, Chapter 13, Subchapter 3, to prohibit the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6 THC, Delta 8 THC, and Delta 10 THC products in the Virgin Islands and for other related purposes, proposed by Senators Clifford A. Joseph Sr. and Maurice C. James. Bill number 36-0184, an act amending Title 22 Virgin Islands Code, Chapter 14, the Virgin Islands Insurance Holding Company System Regulatory Act to implement revisions that were made to the National Associations of Insurance Commissioners, proposed by Senators Milton E. Potter and Novell E. Francis Jr. by the request of the Governor. Bill number 36-0209, an act amending Title 23 Virgin Islands Code, Chapter 10, to establish civil penalties for disregarding marine advisories and to create the Territorial Marine Safety Fund, proposed by Senator Hubert L. Frederick. Bill number 36-0210, an act appropriated the sum of $4 million from the Virgin Islands Insurance Guarantee Fund to the Virgin Islands Water and Power Authority for the repair, replacement, and operation of streetlights throughout the territory, proposed by Senators Kirk A. Vialet and Novell E. Francis Jr. Bill number 36-0217, an act approving the sale of parcel number 20A, Hospital Street, Christiansted, St. Croix, Virgin Islands, by and between the Government of the Virgin Islands and Z Property VI LLC for the sum of $260,000, proposed by Senator Milton E. Potter by the request of the Governor. and Bill number 36-0134, an act repealing and reenacting Title 18, Virgin Islands Code, Chapter 1, Section 2, relating to the government employees' eligibility for elected offices to allow government employees to run for political office while actively employed unless specifically prohibited by federal or other laws, proposed by Senator Marie C. James. Madam Chair, this ends the reading of today's agenda.
Thank you so much, Madam Clerk. It looks like we have 10 bills in this one block as we moved Bill 36-0134 to Block 3. So we'll begin with the first block. First bill in this block, which is bill number 36-0089. And what we'll do, we'll have the persons who are the sponsors of the bill speak on the bill, and then we will have a discussion in block for all of the bills. And then we will vote on the bills. That's the process. So who speaks on behalf of bill number 36-0089? Thank you so much, Senate President Milton Potter. You could proceed.
Thank you, Madam Chair. Colleagues, good afternoon. I offer bill number 36-0089 on behalf of the governor. This bill approves a long-term lease between the government of the Virgin Islands and PEO Productions, LLC, doing business as WSTA Radio, for 3 parcels at Subbase and St. Thomas to support continued radio broadcast operations and related infrastructure. The measure authorizes a 20-year initial term with options for 2 additional 5-year renewals at an annual rent of $30,000 payable in equal monthly installments for the purpose of operating a radio station, radio tower, and related uses on industrial zoned improved property. We all know that WSTA has been a reliable force for good in this community, having been a guiding light through just about every major natural disaster from Hugo to Irma and Maria. Colleagues, at the appropriate time, I urge you to lend your support to this very important initiative. Thank you very much, Madam Chair.
Thank you so much, Mr. President, for that introduction. Who speaks on behalf of bill number 36-0092?
I do, Madam Chair.
Very well. Senator Angel Boquez Jr., you could kindly proceed with your introduction.
Thank you, Madam Chair, and good afternoon, Madam Chair and colleagues. And I rise to bring forward bill number 36-0092 for consideration. A measure that seeks approval for a lease agreement between the government of the Virgin Islands and the St. John Taxi Services Corporation. I must pause to honor the late president of the St. John Taxi Services Corporation, Mr. Sean Claxton, whose recent passing is a loss not only to the organization, but to also the Virgin Islands and the industry of the taxi industry. This bill seeks to modernize the operations of the Taxi Association of St. John, and President Claxton was a man who was at the forefront, who had the vision and the discipline and the commitment and the tough love to be able to work on trying to get this moved forward. Approximately 3.5 years ago, he worked on trying to get this lease agreement moved. This bill has been vetted continuously for a number of times, and I am only saddened that he's not here now to see the movement of this measure to move forward. So, colleagues, as we have deliberated on this bill over and over, it is only best for the modernization of the taxi services of St. John and the plans that they want to bring forward for operations, and of course, to have a better tourism-based experience for our visitors and residents alike. Thank you for the time, Madam Chair.
Thank you so much, Senator Bolkes, for that introduction. Who speaks on Bill number 36-0030? Senator Avery Lewis?
Yes. Good
You're
afternoon
recognized
again,
for your
colleagues.
introduction.
I do speak on behalf of the sponsor, Senator Franklin D. Johnson, and most of others who spoke in favor of this bill. This is an act amending Title 24 Virgin Islands Code, Chapter 1, Section 4, increasing the Virgin Islands minimum wage, which I think is a process that has been long overdue, much needed and fitting in this time. And at the appropriate time, I ask colleagues to support this measure. Thank you.
Thank you so much, Senator Lewis. Who speaks on behalf of Bill number 36-0208?
Thank you. I do again, Madam Chair.
You're recognized.
This is a resolution that's recognizing the help of United States Senator Mike Crapo for his instrumental role in securing the permanent increase in the rum cover-over tax reimbursement for the Virgin Islands, something that is very much needed and will aid our retirement system. And at the appropriate time, again, I do ask my colleagues for their favorable vote. Thank you.
Thank you so much, Senator Lewis. Who speaks on Bill number 36-0105? Senator Clifford A. Joseph, you're recognized.
Yes, colleagues, I offer Bill number 36-0105, an act amending Title 7, Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sales, or manufacture of tetrahydrocannabinolic acid, Delta-6 THC, Delta-8 THC, and Delta-10 THC products in the Virgin Islands and for other related purposes. When this bill was first introduced in August, a loophole existed that has since been closed federally, and the bill was sent back to the Committee on Homeland Security, Justice, and Public Safety. And an amendment in the nature of a substitute was adopted. As the territory, as in the testimony in the Committee on Jurisdiction indicated, this measure is necessary and timely in light of the federal change. And I ask for your continued support of this measure. Thank you, Madam Chair.
Thank you so much, Senator Joseph, for that introduction. Who speaks on behalf of Bill number 36-0184?
I do, Madam Chair.
Senator Milton Potter, Mr. President, you are recognized.
Thank you. Thank you, Madam Chair. Colleagues, I offer Bill number 36-0184 on behalf of the Governor. This bill amends Title 22 of the Virgin Islands Code, Chapter 14, the Virgin Islands Insurance Holding Company System Regulatory Act, to incorporate recent revisions to the National Association of Insurance Commissioners, NAIC, model law on group supervision of insurers. The measure aligns the Virgin Islands insurance regulation with NAIC accreditation standards by adding group capital calculation and liquidity stress test requirements, enhancing receivership-related protections, and strengthening confidentiality, data access, and affiliate oversight provisions to better protect policyholders and the stability of the Virgin Islands insurance market. This bill was vetted in the Committee of Jurisdiction, and at the appropriate time, I'm asking my colleagues to lend your full support to this initiative. Thank you very much, Madam Chair.
Thank you so much, Mr. Senate President, for that introduction. Bill number 36-0209. Who speaks on behalf of this bill?
Do, Madam Chair.
Senator Hubert L. Frederick, you're recognized.
Thank you very much, Madam Chair. Good day, colleagues. I offer Bill number 36-0209, an act amending Title 23 of the Virgin Islands Code, Chapter 10, to establish civil penalties for disregarding marine advisories and to create the Territorial Marine Safety Funds. At the appropriate time, I ask for your support and vote, colleagues, in this measure. It's been already vetted in the initial committee of jurisdiction, and I ask for your continued support in Rules and Judiciary. Thank you very much, Madam Chair.
And thank you so much, Senator Frederick, for that introduction. Bill number 36-0210. Who speaks on behalf of this bill? Senator Novell E. Francis Jr., you're recognized.
Thank you, Madam Chair. I present Bill number 36-0210, really a quality of life measure that speaks to appropriation of a sum of $4 million from the Virgin Islands Insurance Guarantee Fund to the Virgin Islands Water and Power Authority for repair, replacement, and operation of street lights throughout the territory. And of course, $1.8 million is earmarked for St. Croix, 1.2 for St. Thomas and John, and $1 million for payment of outstanding bills. We all understand the safety concerns in regards to lighting up the territory, and this bill seeks to provide an injection to the Virgin Islands Water and Power Authority for that lighting repairs until such times as we could identify a more sustainable and long-term funding. I ask for my colleagues' support on this very important measure. Again, it's quality of life and allowing our seniors to be able to navigate our roadway, especially at night as they have been homebound, consequential to our poor lighting conditions throughout the territory. Thank you very much, Madam Chair, for the time.
Thank you so much, Senator Francis. We have a point of information by Senator Avery Lewis.
Yes, thank you. And Madam Chair, good afternoon again. I'd just like to add, as it pertains to the what the previous speaker just said, Bill 36-0210, with the $4 million from the appropriating the sum of $4 million for the street lighting. Just to add to that, we know that 1.8 is earmarked for lighting in St. Croix, and I think 1.4 is for St. Thomas. But earlier last year, we had already appropriated over $300,000 for the street lighting in St. Thomas already, so that'll be additional moving forward. So this is critical, and I do thank the two sponsors of this bill, because the lighting in this territory is poor and it's much needed. Thank you to the bill sponsors, and I thank my colleagues in advance for your support on this measure. Thank you.
Thank you so much, Senator Lewis, and we are all aware of that. And colleagues, I just want you to know that you will have an opportunity to put your position on debate time once we have finished with the introductions of these bills. Bill number 36-0217. Who speaks on behalf of this bill?
Madam Chair.
Senator Milton Potter. Mr. President, you are recognized.
Thank you, Madam Chair. Colleagues, I offer Bill number 36-0217 on behalf of the Governor of the Virgin Islands. The bill approves the contract of the purchase and sale of parcel number 20A Hospital Street, consisting of approximately 2,000 square feet in Christiansted, St. Croix, between the government of the Virgin Islands and Z Property LLC for $260,000. This satisfies the government requirement in Title 31, Virgin Islands Code, Chapter 21, Section 205, that the legislature authorize the sale of government real property before it can be conveyed. The bill provides administrative efficiency and certainty. The bill ratifies a fully negotiated contract and sets a clear 30-day deadline for the conveyance by a quit claim deed. In terms of the fiscal and economic benefit, the $260,000 purchase purchase price rather converts an underutilized 2,000 square foot parcel into immediate general fund revenue and creates an opportunity for a proven private investment firm and redevelopment entity in the Christiansted town area to make some major improvements in that town. At the appropriate time, I'm asking you colleagues for your support on this very important economic development initiative. Thank you.
Thank you so much, Mr. President, for that introduction. Bill, and then finally we have Bill number 36-0134. Who speaks on behalf of this bill? Mr. Secretary, you're recognized for your introduction.
As it pertains to Bill number 36-0134 on behalf of the sponsor, Senator Marie C. James, this is an act repealing and reenacting Title 18 Virgin Islands Code, Chapter 1, Section 2, relating to government employees' eligibility for elected offices to allow government employees to run for political office while actively employed unless specifically prohibited by federal or other laws. This bill has been properly vetted in the Government Operation, Veterans Affairs and Consumer Protection Committee, and here today we had another round of vetting with the Director of Personnel and her team. All my colleagues, you were here today, who was present, were able to ask the pertinent questions and had inquiries. We understand that there was two particular amendments. We have one in front of us and one is presumably underway, but we saw the language. Colleagues, at the appropriate time, I think that we should take the necessary action. But I'll just say this, on behalf of this bill is just to basically level the playing field and give everyone an opportunity to run for public office and not be have to surrender their rights as a citizens when they plan to run for public service. Again, I'll ask my colleagues for their support at the appropriate time, and thank you very much, Madam Chair, for that.
Thank you so much, Senator Lewis, Mr. Secretary, colleagues. We are going to have a 3-minute, let me put up my hands again, 3-minute debate time on all of these bills in a block. And we will begin with the gentleman who spoke last. Mr. Secretary Avery Lewis, you are recognized for your 3 minutes.
Thank you, Madam Chairwoman. I think I am positive that I'm in support of all the bills in this agenda. I really don't have much to say. I'm really hopeful that the people of the Virgin see that this set of bills here are really impacting lives and touching lives here in the territory. Especially, we are increasing minimum wage, street lighting, saying thank you to our United States Senator. We've banned certain drugs and so forth and taken the necessary steps. And I'd like to thank all the bill sponsors who've worked tirelessly on a lot of these bills, even the rezonings and so forth. I know was a previous colleague from St. John spoke about Mr. Claxton coming on here tirelessly, to champion the cause for the taxi associations in St. John. Again, to his family, my condolences who have beat this conversation tirelessly over and under. And at the appropriate time, Madam Chairwoman, I'll be voting in favor, as far as I could see here. Oh, before I move on, Bill number 36-0209, Senator Frederick brought this bill with the Territorial Marine Safety Fund. People who have these vessels and things in our harbor, or people who just, not just vessels, but people who choose to ignore marine advisories, whatever the advisory is, and think that they're going to go out there and do fun, and then the government just foot the bill, put other people in harm's way. I thank the bill sponsor for his thought process on this, and the vetting that we did, and I look forward for any amendments and anything that's come forward. So again, Madam Chairwoman, I thank you for your time and your indulgence.
And thank you so much, Mr. Secretary, for those great remarks. The chair will now recognize Senator Angel Boquez Jr. for your 3 minutes.
Thank you, Madam Chair. Good afternoon again, Madam Chair and colleagues, listening and viewing audience, central staff. I'm in support of most of the bills in this block. I have some concerns, particularly with two bills, 36-0030, which addresses the minimum wage, but it's silent or it's failing to address several other key issues. It mentions the wage board lapse in the whereas clauses, but it doesn't fix or reactivate or replace the wage board to ensure that ongoing reviews continue to, well, that are supposed to happen. And it provides no sector-specific guidance for industries such as small business or tipped workers. There's no enforcement language in the bill for if businesses do not implement this increase, and there's no business impact or study requirement to track the financial impact of the outcomes of the bill. Also, the bill doesn't hold the governor accountable in a timely manner to appoint the wage board members, which has been vacant for quite some time and mentioned in the whereas clauses of the bill. So those are some of the amendments I believe that the bill needs. As for 36-0210, the concerns that I have there is that we're using a fund that is not intended for this specific purpose. In addition, nothing in the bill is requiring any oversight or any ongoing maintenance or even the incorporation of any energy efficient options for these street lights. Why can't we do solar street lights? That's an option. We should require the Water and Power Authority to look into that technology instead of having to foot the bill for street lights over and over and over again. While I support well-lit communities and I understand the intent, at the same time, we have other critical services that exist across these Virgin Islands. I understand the 4 million is being used in this way, but we have hospitals that we're having a lot of concerns with having the proper equipment for us to save lives in hospitals. Patients are facing shortages in the medications and supplies. EMS fire services are using antiquated equipment. I mean, I could go on, but I understand the intent. I understand. But at the same time, there's a lot of other issues that we need to tackle. So I'm concerned about using or even trying to make it normal for us to use a fund that is not intended for this specific purpose. So those are some of my concerns. Thank you for the time, Madam Chair.
And thank you for your comments, Senator Boquez. I neglected to recognize my good colleague from Savan and Bavonis, the chairman of the Committee on Health, Hospitals, and Human Services, Senator Ray Fonseca. Thank you so much, Senator Fonseca, for being here. Next, the chair will recognize Senator Clifford A. Joseph for your 3 minutes.
Yes, thank you, Madam Chair, and good afternoon to all my colleagues. Madam Chair, I too rise to support maybe most of the bills, and I will agree with the last speaker. When it comes to the street light, I don't think that the whole 4 million need to go in that direction right now. I was dealing with a situation yesterday where I got to find out that the morgue attendants are not working, and family members will have to be waiting some extensive time to be able to go ahead and put the family members to rest. So again, colleagues, we need to really, if we're in a situation we're in right now and every dollar counts, then we need to make sure we stretch the dollar for where it is. So at the appropriate time, I'll be voting on the other 9 of them without question. So, yeah, that's it. Well, again, I'll be in support of 9 out of the 10. So when the appropriate time comes around, I'll be voting. Thank you, Madam Chair, for the time.
Thank you so much, Senator Joseph, for your comments. The chair will now recognize Mr. President Milton E. Potter for your 3 minutes.
Thank you very much, Madam Chair and colleagues. Had an opportunity to discuss just about all of these bills in the Committee of Jurisdiction, and I am prepared to support all, if not the vast majority, of these bills. I know Bill number 36-0134, the bill that would allow government employees to remain on site while running for political office. It's an issue that I can support with the proper amendments, and I understand that that amendment is being worked on right now and should be done by the time we're required to place our vote. So it is something that I can support. Bill number 36-0092. I know my colleague mentioned Mr. Claxton, who was really championing this initiative over the months, and it really has saddened me that he is not going to be here to see the fruits of his time, fruits of his labor. But this bill is one that I definitely will be supporting. That is the lease agreement between the government of the Virgin Islands and the St. John Taxi Services Corporation. My condolences to his family and his loved ones. The minimum wage bill, bill number 36-0030, is one that I can also support. Low-wage workers in the USVI spend just about all of their income on necessities, and they spend it locally on groceries and rent and utilities and transportation. And when you raise their wages, that money immediately recirculates throughout our territorial economy. That is an initiative that I can support. All of the other initiatives here, to include the Territorial Marine Safety Fund, the street lighting initiative, the $4 million for us to provide repair and replacement to the operation of our territory streetlights, is an initiative that is long overdue, I believe. And I am going to reserve the balance of my time, Madam Chair, and provide my colleague from Bavoni an opportunity to utilize those additional couple of seconds. Thank you very much, Madam Chair. What? That's only a minute. A second.
I don't believe it's going to happen, Mr. President. Your time was called. But it's the beginning of a new year, so I am feeling mighty generous, and so I will allow my fellow Bavonian, when that time comes, to place his dialogue on the record and his contribution on the record. At this time, I would like to recognize Senator Marvin A. Blyden for your 3 minutes.
Thank you so much, Madam Chair, and good afternoon again to my colleagues and the people of the Virgin Islands. There are several bills on this agenda that I will be supporting at session because I cannot vote in this committee, but I want to speak to one in particular, which I have been championing and talking about the quality of life and affordability. And you'll be hearing that from me throughout the rest of this term in respect to the cost of living, etc. in the Virgin Islands. So I will be supporting bill number 36-0030, a measure which I am proud to be a sponsor of. And I've worked closely with the author. I am also proud to be able to say that this is an issue that I've been involved in since the beginning of my tenure, which was in 2016. This legislature raised the minimum wage through Act number 7856, of which I was also a sponsor, and created a framework for annual data-driven adjustments. That law also modernized over time and tipped wage protections, but its promise stalled because the wage board had not been seated and required reviews, which never happened. As a result of our minimum wage, it had been frozen at $10.50 since 2018, while costs have surged. I know I have penned a letter to the governor on May 19, 2023, asking him to appoint members to the Virgin Islands Wage Board pursuant to Title 24, Sections 6 and 7, which never happened. But Bill number 36.0030 addresses this lapse. It phases the minimum wage upward toward $15 and clarifies cost of living adjustments starting in 2029, giving employers predictability and restoring purchasing power for workers. Testimonies from the Department of Labor and the Bureau of Economic Research confirms that phase-in increases are manageable and necessary to prevent further erosion of real wages. And our goal is clear: to adapt phase-in increases to catch up and keep up with cost of living. 2, to seat the wage board immediately and enforce annual reviews. And 3, define COLA rules for transparency and planning. This is about governance that works and economic common sense. Virgin Islanders cannot sustain 2025 prices on 2018 wages. Let us advance Bill number 36.0030, which with amendments needed for fairness, predictability, and fidelity to the framework we established since 2016. So, Madam Chair, I will be supporting that when it comes to the floor, and also some of the other measures on this agenda. Thank you so much for the time.
And thank you so much, Senator Blyden, for your commentary on that measure. The chair will now recognize Senator Novell E. Francis Jr. for your 3 minutes.
Thank you very much, Madam Chair. I stand in support of all of the measures in this particular block. And of course, there are several amendments that's being offered in an effort to strengthen these pieces of legislation moving forward. In respect to the streetlight measure, I want to say that I don't want the public to get any idea that this body has not funded the hospital adequately. We continue to fund our hospitals. We just gave $13 million recently. Every single week, I have the responsibility of the chair to, again, navigate, move money around, and encourage some payment to our hospital facilities. And there's no way, shape, or form our intention, because we're trying to provide street lighting to our community, that we're not funding our hospital facilities. That is the furthest thing from the truth. The Insurance Guarantee Fund is very much related to the fact that the storms of the 2017 and beyond have been instrumental in knocking out some of our streetlights throughout the territory. While there have been some effort to install composite poles in other areas, streetlights continue to be challenged, and that's the reason why we're, again, ensuring that we get in the street lights. Not to mention the fact that the poor lighting situation have increased the number of traffic accidents that we have seen during the course of the night. Also add to the struggle that we're seeing, and I believe that the use of the Insurance Guarantee Fund is very much related to being able to provide some assistance in being able to get our street lights going. In respect to the hospital street purchase, it's our intention at a later time for us to be able to move an amendment that the monies collected from that sale will go towards the go back to the historic preservation for grants to support initiative in improving some of our buildings and infrastructure within our town areas, paint and scrape and reconditioning of some of those facilities. So that's an amendment that will be offered sometime later on, and I'm hoping that my colleagues could support that. Again, I will be in support of most of these measures here. I don't have a vote in this committee. However, when it comes to the general, I will be voting in favor of it. Thank you very much, Madam Chair, for the time.
And thank you so much, Senator Francis, for staying within your time frame. The chair will now recognize Senator Alma Francis Heiliger for your 3 minutes.
Thank you so much, Madam Chair. Let's see if we could get through this 3 minutes. As it relates to Bill number 360089, I fully support this piece of legislation. As a fellow radio station owner, I know how important it is to have that stability while you're providing a haven to the public so they could get information as well as share their thoughts. So I understand. 360092. This one has to do with the taxi. I know initially several taxis had contacted me. Some of them had a lot of concerns over how it was initially being run. I don't think I'm fully over some of those concerns. So I might need a little bit more time by the time we get to session, I think is Monday. So I will make a decision by then, but you know, I'm still getting calls over this one. 360030, I do support, I understand the cost of living. I think we should have done a much better job in making sure that board had adequate people on it to give us a report so a better decision could be made. But sometimes when you see things are not happening, we have to step in and based on law to make those adjustments. 360208, from a personal level, I would like to thank Senator Mike Kreppel for his part that he played as it relates to dealing with this situation of the rum cover over taxes and assisting us. As you know, many senators, I know the governor and his team. I also know that our delegate to Congress, Stacey Plaskett, and several others work collectively for it to ultimately reach to Senator Mike Kreppel. But in all honesty, after doing a little bit more research, listening, I will not be touching this bill with a 10-foot pole because I'm not getting involved in the local political aspects of it. Bill number 360105, this particular bill, I will make a decision. This one has to do with the hemp and the THC. I'll make a decision accordingly. 360184. I don't have a problem with this piece of legislation as it relates to when it comes to insurance holding here in the territory. Bill number 360209, as it relates to having some kind of civil penalties when it comes to the marine industry. There's a lot of times in these hurricanes, people still choose to put themselves in danger and not come out of these boats or these situations. And it causes a lot of issues and sometimes even a loss of life. So just try to protect yourself and come inshore and find safety. As it relates to 360210, you know, initially I was not too happy that the funds were coming out of the insurance guarantee fund because I know exactly what this fund was created for. But sometimes when you talk about guaranteeing safety of the people, not only for their homes, as an individual whose street lights on their street have been out since the hurricane, a lot of times I try to go home before dark. Even if I have to stay out late, I have to make a conscious decision because if it's not for the light in my phone, I can't even figure out how to get from my car to my stairs. So I see how that is also a danger to public safety and health. So I definitely hope that this situation would help.
Time.
Could I just wrap up the last two?
Certainly.
Thank you. As it relates to 360217, I do support this piece of legislation in regards to the sale of the roughly 2,000 square foot parcel for the purposes that were duly explained. And as it relates to 360134, I do not plan on being a hindrance to anyone that wishes to run for public office. And this piece of legislation attempts to, according to the sponsor, make it a little bit easier. So the only thing I will say is I do have an amendment I will be offering that will add where for the last 30 days, after we discussed it with several of my colleagues, we came up with this 30-day option. For the last 30 days, when we who have already run already know how vigorous it is, that those 30 days they will have to take leave of absence and utilize their annual leave. So thank you very much, Madam Chair. That is my opinion on all of these legislation, and I will vote accordingly.
And thank you so much, Senator Francis Heiliger, for your commentation on those areas. The chair will now recognize Senator Hubert Frederick for your 3 minutes.
Thank you very much, Madam Chair. Pleasant good afternoon, all colleagues, listening and viewing audience. Madam Chair, I am in support of most, not all, of the amendments today being discussed. In particularly, some I believe would be fine if supported with an amendment to strengthen these pieces of legislation. In particular, the minimum wage, in which I support. However, I think it should be amended for mom and pop businesses that will not be able to afford paying higher wages for their small businesses at this time. It should be done in a graduated form. We tend to always ask, why is it we don't see more businesses lined up when the cruise ships are here and more vendors out? Well, it's because they don't make a lot of money as it is. And if they have to pay people $16 an hour, why are they gonna even come down and try to provide a service? So if we're gonna be serious about having a more festive environment for when cruise ships come, or we wanna see more small pop-ups around, we're gonna have to have an amendment to allow people to pay a little less because they're not able to carry that heavy cost of labor. That's just factual. This has nothing to do with the ability to buy a home and live a better life. This is minimum wage we're talking about. We have to make sure we provide our businesses an opportunity to survive. So with the appropriate amendment, I think this would be a great piece of legislation. For those businesses that could afford it, there's no problem. You could increase the minimum wage. But I want everyone to remember, all prices will increase. So if you think the cost of living in the Virgin Islands is high today, wait until we implement the increase in minimum wage. That's just business. They don't eat the cost, they pass it on to consumers. So if you're willing to pay more, increase your minimum wage. Remember, our federal minimum wage is still $7.25. The U.S. Virgin Islands is at $10.50. Puerto Rico is less than ours. We need to maintain our competitive edge when it comes to tourism. We need to keep the costs down in our economy, and the way you do it is to keep costs down, not just increasing. That is my little speech on the matter. We'll let the results bear fruit when the Bureau of Economic Research comes back next year and tell us the impact on inflation because of these increases. This is my pronouncement. You can measure what I said next year when you see the prices go up. Not that I want it to go up, but it will go up. In reference to my bill, which is bill number 36-0209, Madam Chair, if I could wrap it up.
You may proceed, Senator.
Thank you very much. The reason why this marine bill came up was specifically because of people disregard to warnings about how dangerous the weather conditions are, and they decide to go out for a little thrill and still do whatever they want to do out there, and then they get into some trouble, and we have to send help to help them, and it now risks the lives of our first responders and our equipment. And I thought, if we're going to do that, we're going to have to provide a civil penalty so that they understand you just can't do stuff like that and get away with it without paying anything, because it's a cost to us as a government. It's important that we cover costs. I know people sometimes think I talk too much about costs, but it's coming out of my pocket and your pocket. If it wasn't coming out of my pocket, fine. But someone has to pay for these things. That's why my constituents put me in office, to hold the cost down in government, and that's what I intend to do. Thank you very much, Madam Chair, for the time.
And thank you so much, Senator Frederick. I know you chair that powerful committee of economic development and agriculture, so you have to be cognizant of a cost. And yes, everything has a cost associated with it. Sometimes we don't see it, but we feel it. At this time, the chair would like to recognize Senator Ray Fonseca for your 3 minutes.
Thank you, Madam Chair, and thanks to my colleague. And Madam Chair, I'm not a member of this committee, but I wanted to express my strong support for the judicial nomination of Attorney Pedro Williams. As you know, my mother name is Lynell Williams, so I'm Ray Williams Fonseca. So I saw the big contingent, a lot of Williams. My family was here, and I want to let you know that I will be voting in the favor of this nomination at the appropriate time, and we couldn't vote on a better person for that judge. Also, I want to say happy birthday to my staff member. You could see him right here in the back of me, Mr. Rafael Jose Conero. Everybody call him Rafi. Rafi, happy birthday. I think he make about 58 or so today. Madam Chair, I voted in favor of Bill number 36-0210 in the committee chaired by the Honorable Senator Avery Lewis, Government Operations, Consumer Protection, Veterans Affairs. But I wanted to bring to your attention something that came up. And you know, the Rules Committee is the clearinghouse. Sometimes when bills are approved, they have to be further vetted, and you get another opportunity in the Rules Committee. So I was looking at the letter from Julio Reimer, the second page on the second paragraph, and where he said the Water and Power Authority, based on the code, receives 4% of property taxes. Based on the collections, they're getting about $2.4 million. And he also said that we need to determine the true costs of repairs and maintenance of streetlights, and also that WAPA should look at different alternative sources, such as solar, et cetera, et cetera. And now when I go to the letter from the WAPA director, dated December 15th, on paragraph 4, the first sentence, he was saying that the street lighting initiative is underfunded by $8.3 million. Now, the codes say we have to give them 2.4. We've been giving WAPA the 2.4. But WAPA is still saying they're underfunded by $8+ million. But, Madam Chair, just last year, when the state of emergency was declared by WAPA, the government of the Virgin Islands gave WAPA $32,118,838.05 from the general fund, from the budget stabilization fund, from ARPA fund. Now we're giving WAPA. Madam Chair, can I wrap up?
You may proceed, Senator. You may
Yes.
proceed to wrap up.
Now, there's an issue with the hospitals. Colleagues, we're getting ready to open a new cancer center in this quarter. And breast cancer, as you know, is the #1 cause of death in females in this territory. And the breast cancer machine is inoperable. It's going to cost $500,000. I'm saying, colleagues, WAPA is even saying they need $8.3 million. So even the $4 million that we're about to give them is not going to be enough. It's less than half. So I'm coming with an amendment for $500,000 so that we can have a breast cancer machine in the Charlotte Kinnelman Cancer Center, so that we can be able to treat breast cancer, and the ladies will be able to go there and get screened. We cannot ever open that cancer center without a breast cancer screening machine for the women. So thank you so kindly for the time, Madam Chair.
Thank you so much, Senator Ray Fonseca. Senator Francis Heiliger, you have a point of information?
Yes, I just wanted to know for clarity, because I know, just so I could understand, I know with the rebuild of the Charlotte Community Center, wasn't FEMA saying they're going to pay to completely furnish and put back all the equipment? So I'm trying to understand that part just for clarity.
And so that's through the chair to Senator Fonseca. Senator Fonseca?
Thank you, Madam Chair. The way how it works is that FEMA would replace the equipment that was there and that was damaged. At the time, the breast cancer machine was operable and functioning, but it has since gone offline. And so this is a new machine that is not eligible for that funding because it wasn't damaged. Thank you, Madam Chair.
Thank you so much, Senator Fonseca, for providing that clarification. And thank you, Senator Francis Heiliger, for that question, because I had that question in my head too. All right, colleagues, I stand ready to vote at the time for all of the bills. Now, I do have entered 2 amendments to 2 of these bills, and I really want to commend all of the committees that worked on bills to get them to this point, and specifically bill number 36-0105. When this bill was heard in the Committee of Jurisdiction, the Commissioner of Health mentioned that she had some issues with Section 3 and having these products on the shelves still because federal law indicates that they need to be removed. So I have entered an amendment, but it's not ready, and hopefully on session day will be ready. That will strictly prohibit the selling and or distribution of these products. And the products specifically are the tetrahydrocannabinoic acid delta 6, THC delta 8, THC, and delta 10 THC. So that was one of the contentions with this bill. I worked with the Commissioner of Health as well as the primary sponsor of this legislation to put together an amendment, and hopefully on session day it will be ready. And also, I really want to, we should be able to give people positive, especially when they're working for us. I know they're doing their required job, but they didn't have to step out. And so I definitely am going to also offer an amendment for the resolution, the only resolution we have, which is 36-0208, recognizing the United States Senator Mike Crapo for his instrumental role in securing a historic increase in the rum cover over tax reimbursement for the Virgin Islands. Really, it's just a very small amendment. I did put it in from way back, but it's not ready today. So hopefully on legislative session day, I can offer that amendment. And I stand ready to support all of the measures in this block. I mean, there are concerns relative to the minimum wage, and I appreciate that. And the economics, macroeconomics tells us that we are going to see increases in the cost of living. Those costs are absorbed some way. And so it's either you're going to be rising costs. So, but the Bureau of Economic Research was behind of this bill 36-0030, and they said it should be done in a graduated manner. So I do appreciate it. And regarding the sum, the $4 million from the Insurance Guarantee Fund to the Virgin Islands Water and Power Authority for the repair, replacement, and operation of streetlights throughout our territory, I really think it's something about safety. That's what I'm looking at. Because people could get harmed. In fact, I had a conversation with a gentleman just yesterday when I went to pick up some grocery at the corner store, and he said it's very dangerous for our pedestrians as well as our automobile vehicle operators on some of these streets, and I can appreciate that. And so we want to be able to give them those assurances that, we're providing the money. My only concern with WAPA, I'm going to just put it on the table, is that we have to work and see how we could get that accountability and that reliability and affordable energy. Energy is everything. Energy is the key for our economy to grow here in the Virgin Islands. So whatever we could do to support WAPA and hold them accountable, this is what this body should do, and we've been doing that consistently. So colleagues, I am prepared and ready to vote on all measures. Do I hear a motion? Motion. Senator Milton Potter, Mr. President, you're recognized for your motion.
Thank you very much. Thank you very much, Madam Chair. Madam Chair, I move that bill number 36-0089, an act approving the lease agreement between the government of the Virgin Islands and PEO Productions, LLC, doing business as WSTA Radio for parcel number 121, Submarine Base, number 6, Southside Quarter, St. Thomas, Virgin Islands, parcel number 167, subbase number 6, Southside Quarter, St. Thomas, and parcel number 171, subbase number 6, Southside Quarter, St. Thomas, be favorably voted upon by the Committee on Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Bill number 36-0089 has been properly moved by Senator Milton Potter, seconded by Senators Joseph, Lewis, and Francis Heiliger. Roll call on bill number 36-0089.
Senator Angel L. Bocas Jr.
Yay.
Senator Bocas Jr., yay. Senator Kenneth L. Gittins. Senator Gittins, absent. Senator Alma Francis Heiliger? Yes. Senator Francis Heiliger, yay. Senator Carla J. Joseph?
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr.? Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis? Yes. Senator Lewis, yay. Senator Milton E. Potter?
Yes.
Senator Potter, yay. Madam Chair, you have 6 yay, 1 absent.
Thank you, Madam Clerk. Bill number 36-0089, an act approving the lease agreement between the Government of the Virgin Islands and PEO Productions, LLC, doing business as WSTA Radio for parcel number 121, Submarine Base number 6, Southside Quarter, St. Thomas, Virgin Islands, parcel number 167, subbase number 6, Southside Quarter, St. Thomas, and parcel number 171, subbase number 6, Southside Quarter, St. Thomas, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Do I hear a motion?
Motion.
Senator Angel Bocas Jr., you're recognized for your motion.
Thank you, Madam Chair. Madam Chair, I move bill number 36-0092, an act approving the lease agreement between the Government of the Virgin Islands and St. John Taxi Services Corporation for parcel number D-2 Estate Cruise Bay Town, Cruise Bay Quarter, St. John, Virgin Islands, to be favorably voted upon in this committee and reported out to the full body for further action and consideration. I so move.
Bill number 36-0092 has been properly moved by Senator Angel Bocas Jr., seconded by Senators Clifford Joseph, Milton Potter, and Lewis. Roll call on bill number 36-0092.
Senator Angel L. Bocas Jr.,
Yay.
Senator Bocas Jr., yay. Senator Kenneth L. Gittens, Senator Gittens absent. Senator Alma Francis Heiliger, Senator Francis Heiliger not voting. Senator Carla J. Joseph,
Yes.
Senator Joseph Yeh. Senator Clifford A. Joseph Sr., Senator Joseph Sr., yay. Senator Avery L. Lewis, Senator Lewis, yay. Senator Milton E. Potter, Senator Potter, yay. Madam Chair, you have 5 yeas, 1 absent, 1 not voting.
Thank you, Madam Clerk. Bill number 36-0092, an act approving the lease agreement between the Government of the Virgin Islands and St. John Taxi Services Corporation for parcel number D-2 Estate Cruise Bay Town, Cruise Bay Quarter, St. John, Virgin Islands, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Do I hear a motion? Senator Avery Lewis, you are recognized for your motion.
Thank you, Madam Chair. Madam Chair, I move Bill number 36-0030, an act amending Title 24 Virgin Islands Code, Chapter 1, Section 4, increasing the Virgin Island minimum wage, to be voted upon favorably in the Committee of Rules and Judiciary and forwarded to the full body for further vetting and action. I so move.
Bill number 36-0030 has been properly moved by Senator Avery Lewis and seconded by Senators Joseph and Potter. Roll call on Bill number 36-0030.
Senator Angel L. Bocas Jr.,
Yeah.
Senator Bocas Jr., yay. Senator Kenneth L. Gittens, Senator Gittens absent. Senator Alma Francis Heiliger,
Yes.
Senator Francis Heiliger, yay. Senator Carla J. Joseph,
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr.,
Yes.
Senator Joseph Sr., yay. Senator Avery L. Lewis,
Yes.
Senator Lewis, yay. Senator Milton E. Potter,
Yes.
Senator Potter, yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you so much, Madam Clerk. Bill number 36-0030, an act amending Title 24 Virgin Islands Code, Chapter 1, Section 4, increasing the Virgin Islands minimum wage, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Do I hear a motion?
Motion.
Senator Avery Lewis, you're recognized for your motion.
Madam Chair, I move Bill number 36-0208. Let me start over. Sorry. Madam Chair, I move Bill number 36-0208.
There you go.
A resolution recognizing United States Senator Mike Craper for his instrumental role in securing the historic increase in the rum cover tax reimbursement for the Virgin Islands. Be voted upon favorably in the Committee of Rules and Judiciary and forwarded to the full body for further vetting and consideration. I so move.
Bill number 36-0208 has been properly moved by Senator Avery Lewis and seconded by Senators Milton E. Potter and Clifford A. Joseph. Roll call on Bill number 36-0208.
Senator Angel L. Bocas Jr.,
Yeah.
Senator Bocas Jr., yay. Senator Kenneth L. Gittens, Senator Gittens absent. Senator Alma Francis Heiliger, Senator Francis Heiliger not voting. Senator Carla J. Joseph, Senator Joseph, yay. Senator Clifford A. Joseph Sr.,
Yes.
Senator Joseph Sr., yay. Senator Avery L. Lewis,
Yes.
Senator Lewis, yay. Senator Milton E. Potter,
Yes.
Senator Potter, yay. Madam Chair, you have 5 yeas, 1 absent, 1 not voting.
And thank you so much, Madam Clerk. Bill number 36-0208, a resolution recognizing United States Senator Mike Crapo for his instrumental role in securing the historic increase in the rum cover-over tax reimbursement for the Virgin Islands has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. Do I hear a motion? Senator Clifford A. Joseph, you are recognized for your motion.
Madam Chair, I move Bill number 360105, an act amending Title 7, Virgin Islands Code, Chapter 13, Subchapter 3, by prohibiting the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6 THC, Delta 8 THC, and Delta 10 THC products in the Virgin Islands and for other related purposes, be favorably approved by the Committee on Rules and Judiciary and forward on to the full body for further consideration. I so move.
Bill number 36-0105 has been properly moved by Senator Clifford A. Joseph and seconded by Senators Milton Potter and Avery Lewis. Roll call on Bill number 36-0105.
Senator Angel L. Bolkes Jr.
Yay.
Senator Bolkes Jr., yay. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Alma Francis Heiliger. Senator Francis Heiliger not voting. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr.
Yes.
Senator Joseph Sr., yay. Senator Avery L. Lewis.
Yes.
Senator Lewis, yay. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Madam Chair, you have 5 yeas, 1 absent, 1 not voting.
Madam Chair, kindly change, I'm sorry, thank you. Madam Clerk, kindly change Senator Francis Heiliger's vote to yes and give us the tally once again.
You have 6 yeas, 1 absent.
Thank you so much, Madam Clerk. Bill number 36-0105, an act amending Title 7 Virgin Islands Code, Chapter 13, Subchapter 3, to prohibit the possession, sale, or manufacture of tetrahydrocannabinolic acid, Delta 6 THC, Delta 8 THC, and Delta 10 THC products in the Virgin Islands and for other related purposes have been favorably voted on in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. Do I hear a motion? Senator Milton Potter, you're recognized for your motion.
Thank you, Madam Chair. Madam Chair, colleagues, I move that Bill number 36-0184, an act amending Title 22 Virgin Islands Code, Chapter 14, the Virgin Islands Insurance Holding Company System Regulatory Act, to implement revisions that were made to the National Association of Insurance Commissioners, be favorably voted upon by this body, this committee, Committee on Rules and Judiciary, and forwarded to the full body for further consideration and action. I so move.
Bill number 36-0184 has been properly moved by Senator Milton Potter, seconded by Senator Clifford A. Joseph and Avery Lewis. Roll call on Bill number 36-0184.
Senator Angel L. Bolkes Jr.
Yeah.
Senator Bolkes Jr., yay. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr.
Yes.
Senator Joseph Sr., yay. Senator Avery L. Lewis.
Yes.
Senator Lewis, yay. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. Bill number 36-0184, an act amending Title 22, Virgin Islands Code, Chapter 14, the Virgin Islands Insurance Holding Company System Regulatory Act, to implement revisions that were made to the National Association of Insurance Commissioners, have been favorably voted upon in the Committee on Rules and Judiciary, and will be forwarded to the full body for further action and consideration. Do I hear a motion?
Motion.
Senator Angel Boquez, you are recognized for your motion.
Thank you, Madam Chair. Madam Chair, I move Bill number 36-0209, an act amending Title 23 Virgin Islands Code, Chapter 10, to establish civil penalties for disregarding marine advisories and to create the Territorial Marine Safety Fund, to be favorably voted upon in this committee and reported out to the full body for further consideration and action. I so move.
Bill number 36-0209 has been properly moved by Senator Angel Boquez Jr., seconded by Senators Lewis, Clifford A. Joseph, and Milton E. Potter. Roll call on Bill number 36-0209.
Senator Angel L. Boquez Jr.
Yea.
Senator Boquez Jr. Yea. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger yea. Senator Carla J. Joseph.
Yes.
Senator Joseph yea. Senator Clifford A. Joseph Sr.
Yes.
Senator Joseph Sr. yea. Senator Avery L. Lewis.
Yes.
Senator Lewis yea. Senator Milton E. Potter.
Yes.
Senator Potter yea. Madam Chair, we have 6 yeas, 1 absent.
Thank you, Madam Clerk. Bill number 36-0209, an act amending Title 23 Virgin Islands Code, Chapter 10, to establish civil penalties for disregarding marine advisories and to create the Territorial Marine Safety Fund, has been favorably approved in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Do I hear a motion? Senator Avery Lewis, you're recognized for your motion.
Thank you, Madam Chair. Madam Chair, I move Bill number 36-0210, an act appropriating the sum of $4 million from the Virgin Islands Insurance Guarantee Fund to the Virgin Islands Water and Power Authority for the repair, replacement, and operation of streetlights throughout the territory. I move that this bill be voted upon favorably in the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Bill number 36-0210 has been properly moved by Senator Avery Lewis and seconded by Senator Milton E. Potter. Roll call on Bill number 36-0210.
Senator Angel L. Boquez Jr.
Nay.
Senator Boquez Jr. Nay. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger yea. Senator Carla J. Joseph.
Yes.
Senator Joseph yea. Senator Clifford A. Joseph Sr.
Not voting.
Senator Joseph Sr. not voting. Senator Avery L. Lewis.
Yes.
Senator Lewis yea. Senator Milton E. Potter.
Yes.
Senator Potter yea. Madam Chair, you have 4 yeas, 1 nay, 1 absent, 1 not voting.
Thank you so much, Madam Clerk. Bill number 36-0210, an act appropriating the sum of $4 million from the Virgin Islands Insurance Guarantee Fund to the Virgin Islands Water and Power Authority for the repair, replacement, and operation of streetlights throughout the territory, has been favorably approved in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Do I hear a motion?
Motion.
Senator Milton Potter, you're recognized for your motion.
Thank you, Madam Chair. Madam Chair, colleagues, I move that Bill number 36-0217, an act approving the sale of parcel number 20-A, Hospital Street, Christiansted, St. Croix, Virgin Islands, by and between the government of the Virgin Islands and Z Property VI LLC for the sum of $260,000 be favorably considered in this Committee on Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Bill number 36-0217 has been properly moved by Senator Milton E. Potter, seconded by Senator Clifford A. Joseph. Roll call on Bill number 36-0217.
Senator Angel L. Bolkes Jr.
Yeah.
Senator Bolkes Jr. Yay. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger. Yay. Senator Carla J. Joseph.
Yes.
Senator Joseph. Yay. Senator Clifford A. Joseph Sr.
Yes.
Senator Joseph Sr. Yay. Senator Avery L. Lewis.
Yes.
Senator Lewis. Yay. Senator Milton E. Potter.
Yes.
Senator Potter. Yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. Bill number 36-0217, an act approving the sale of parcel number 20-A, Hospital Street, Christiansted, St. Croix, Virgin Islands, by and between the government of the Virgin Islands and Z Property VI LLC for the sum of $260,000 have been favorably approved in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. Do I hear an amendment?
Amendment.
Senator Francis Heiliger, you're recognized for your amendments.
Did we offer the bill yet?
We already spoke on the bill, and it's already, we could offer it.
Okay. I know we discussed them, but I thought you have to offer them individually, but I'll make sure.
We did.
Okay.
It was already conducted, it was already introduced, and we already spoke on all of them. Yes, and it's not a problem. You can proceed.
Thank you. I offer amendment number 36-610 to Bill number 360134. Bill number 360134 is amended in Section 1, subsection 2B by inserting the following at the end. Quote, semicolon, except that a government employee seeking public office must be granted technical amendment and take paid leave from their accumulated annual leave 30 days prior to the general election. I so move.
Amendment number 36-610 to Bill number 36-0134 has been properly moved by Senator Alma Francis Heiliger, seconded by Senator Milton E. Potter and Clifford A. Joseph Sr. Hearing no objections, so ordered. Motion. Senator Avery L. Lewis.
Thank you, Madam Chair. I move Bill number 360134 as amended, an act repealing and reenacting Title 18 Virgin Islands Code, Chapter 1, Section 2 related to government employees' eligibility for elected offices to allow government employees to run for political office while actively employed unless specifically prohibited by federal or other laws, be voted upon favorably in the Committee of Rules and Judiciary and forwarded to the full body for further action and consideration. I so move.
Second.
Bill number 36-0134 has been properly moved by Senator Avery L. Lewis, seconded by Senator Milton Potter and Clifford A. Joseph Sr. Roll call on Bill number 36-0134 as amended.
Senator Angel L. Bocas Jr.
Nay.
Senator Bocas Jr. Nay. Senator Kenneth L. Gittens. Senator Gittens absent. Senator Alma Francis Heiliger. Senator Francis Heiliger not voting. Senator Carla J. Joseph. Senator Joseph not voting. Senator Clifford A. Joseph Sr.
Yes.
Senator Joseph Sr. Yea. Senator Avery L. Lewis.
Yes.
Senator Lewis Yea. Senator Milton E. Potter.
Yes.
Senator Potter Yea.
Madam Clerk?
Go ahead.
Madam Clerk, please change my vote to yea.
Mine to yes.
And also change Senator Alma Francis Heiliger vote to yea.
Madam Chair, you have 5 yeas, 1 nay, 1 absent.
Thank you so much, Madam Clerk. Bill number 36-0134, an act repealing and reenacting Title 18 Virgin Islands Code, Chapter 1, Section 2, relating to government employees' eligibility for elected office, to allow government employees to run for political office while actively employed, unless specifically prohibited by federal or other laws, as amended, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action.
Point of personal privilege.
Senator Avery Lewis, you are recognized for your point of personal privilege.
Again, good afternoon to my colleagues. Good afternoon to the people of the Virgin Islands. I'd just like to take this moment just to say there's something seriously going wrong and everybody's getting sick, getting the flu, getting the cold, getting something. I just want us to take extra caution. Let's, personally, let's revert back to some of those maybe possible COVID ways, cover your mouth, wash your hands a little more. Let's do the right thing. Let's take our vitamins. Let's keep healthy. Let's keep our families and ourselves safe and healthy. That's all I'm asking for a healthier community. Thank you very much. God bless us all.
And thank you so much, Senator Lewis. I would like to add also...
Point of personal privilege.
I will recognize you right now. Senator Volquez, you may proceed with your point of personal privilege.
Thank you, Madam Chair. I was trying to get your attention for a few. My point of personal privilege derives from my vote. I want to be abundantly clear that during the deliberation concerning the measure for employees running for office, there was said that there's a number of amendments that were going to be provided. There was only one amendment that I am aware of, which we voted on, and I have not seen the other amendments. So until those amendments are generated, I suppose at this point in time, this meeting is about to adjourn, then I will decide how I vote on this measure. But I want to make sure that that's on the record. During the deliberation, there was a number of amendments that were discussed, and I only heard about one just a moment ago. Thank you for the time, Madam Chair.
And thank you so much, Senator Volquez, for that point of information. Senator Alma Francis Heiliger, you had a point of information or a point of personal privilege?
Yes, thank you.
Which one?
I wanted to just touch on the one I abstained on.
Point of information?
No, yes.
Okay, proceed.
Well, or point of personal privilege is what I originally said.
I think that's what I was asking.
Yes.
Point of personal privilege?
Thank you.
Okay.
I just wanted to share my thoughts as to why I specifically abstained on one piece and I kind of changed my thoughts on the other. I do have the same thought process with my predecessor that just spoke, and I was a little concerned that these additional amendments had not arrived as yet because my one showed up very late. So I am going to take that leap and hopefully they're going to show up in session and I will make a much better decision whether to move forward with this piece of legislation or not. But for now, I have voted to allow it to come out of the committee and move forward to the Senate floor. Thank you.
And thank you so much, Senator Francis Heiliger, for that commentary. I want to also mention that I signed on to a drafting request, which was one of the amendments to Bill number 36-0134. I hope I'm saying the correct bill. Yes, I am. 36-0134, and that's the bill that we had the discussion with the Director of Personnel, and I know it's not going to be ready today. It wasn't. We were pushing to get it ready today, but it doesn't look like it's going to come out. So hopefully, I took that leap of faith that it'll be ready for session. I want to also, piggyback on what the secretary mentioned regarding people, making sure that we practice the courtesy if we have a cold, to make sure we wash our hands, cover our mouths, but also that we definitely increase our vitamin intake. And if you know you have a cold, take something for it. You take whatever type of vitamins you need to take for it. And drink plenty water. Water is always good. Colleagues, this completes our agenda for today. I am very grateful for all of you, to all of you who are here in the chambers, all my senators. We had 11 senators present. Wonderful at various times. I want to thank our hard-working central staff. We came off of recess with a bang, and so the work continues now to move things forward. I also want to thank my very hard-working staff who work behind of me all the time, and I'm definitely appreciative of them for the work that they do. And my members, I really got to say thank you for getting everything done. The stenographers, Sergeant of Arms, Central Staff, media, I just really want to say thank you for the hard work you do. The Committee on Rules and Judiciary hearing for Thursday, January 8th, 2026 is hereby adjourned.